हेलो एंड वेलकम टू श्रीराम IAS, वेलकम टू दिस क्लास। आपका अभिनंदन है और आई होप यू ऑल आर डूइंग फाइन, यू आर डूइंग बेस्ट इन योर प्रिपरेशन फॉर योर अपकमिंग एग्जामिनेशन ऑन 25th of May 2025. तो करंट अफेयर फॉर्म्स अ वेरी इंपॉर्टेंट पार्ट ऑफ योर प्रिपरेशन. Indian Polity forms a very important part of your preparation. Around 15 to 20 questions in prelims exams are asked from Indian Polity. And if you see, कहीं ना कहीं अगर आप देखें तो करंट अफेयर्स में जो चल रहा है वहाँ से क्वेश्चंस निकाल के पूछे जाते हैं. तो इसी वजह से अपन ये सीरीज़ लेकर आए हैं. श्रीराम IAS आप लोगों के लिए ये सीरीज़ लेकर आया है जिसमें 50 मोस्ट इंपॉर्टेंट टॉपिक्स विल बी डिस्कस्ड फॉर योर अपकमिंग एग्जामिनेशन. This will be done in all the subjects, not only polity. The next faculty for economics, environment and other subjects will also come up with their respective classes. तो यहाँ से अपन चालू करेंगे इंडियन पॉलिटी को लेके. एंड दिस इज अ वेरी इंपॉर्टेंट सब्जेक्ट. इट कैन मेक और ब्रेक थिंग्स फॉर यू. If you prepare this subject really very well, if you prepare the current affairs for polity really very well, it is going to help you a lot. Think about the situation कि 20 questions अगर आपसे पूछे गए हैं prelims examination में और 20 के 20 अगर आपने सही कर दिए तो 40 नंबर दिलवाता है वो. It is very important. So please pay attention here to what I am doing, what I am saying, and let us study together the most important topics of Indian polity. अगर predict करा जाए तो इन टॉपिक्स में से there is a high probability that questions can be asked. So be with me, and if you have any question you can ask me directly. So I am Mayank Bharadwaj presenting this Indian Polity class. This is the topic number 1. Let's start the class. So the Lieutenant Governor, gentleman is the Lieutenant Governor, Honorable Lieutenant Governor of Jammu and Kashmir. इन्होंने क्या करा है? He has removed 2 employee of the Jammu Kashmir services. अब क्वेश्चन यहाँ पर उठता है, can the civil servants be removed? So the protection has been given under Article 311 in the Constitution for the protection of the civil servant. There are several immunities which are given. So it is a very important Article 311. You should pay attention when you are preparing for it. You are also going to become a civil servant. So it is also important for you to know what is Article 311 and how it is different from Article 361. This is another very important article which although does not give protection to the civil servants but gives protection to the president and governors. We are going to see this article which is going to come later on. So this was one of the news of the current affairs which we are going to study. So Article 311 is a very important part when it comes to the civil services and the establishment of civil services. This gives certain protections. If a civil servant has to be removed, there has to be a procedure which should be followed. They cannot be removed on the whims and the fancies of the executive. सबसे important चीज, कोई भी civil servant अगर आपको remove करना है तो वो उस authority से नीचे की rank वाला इंसान remove नहीं कर सकता जिसने उसे appoint किया है. For example, a civil servant has been appointed by the honorable governor. तो उसको रिमूव करने का पावर गवर्नर से नीचे की रैंक के अधिकारी के पास नहीं है. ओनली द गवर्नर कैन रिमूव द पर्सन, द सिविल सर्वेंट. ये सबसे पहली शर्त है. दूसरी शर्त, इफ द पर्सन हैज टू बी रिमूव्ड देन it is very important to communicate to the person, to communicate to the civil servant the grounds on which the civil servant has to be removed. ये आर्टिकल 22 जैसा लग रहा होगा आपको. Right against arrest and detention, where a person is arrested, the grounds has to be communicated. He should be given the opportunity to represent himself and presented in front of a magistrate within 24 hours. But this is a different article. That is the right which has been given to a person who has been arrested. Right against arrest and detention, that is a different thing altogether. Here it is a different thing. 311, when a civil servant is removed, there shall be a procedure which should be followed. It cannot be done arbitrarily. Civil services, today is Civil Services Day. Civil services forms the backbone of the whole governance structure of the country. It is the heart of the governance structure of the country. And if civil servants are removed arbitrarily on the whims and fancies of the political class, then what will happen? How will the country survive? How will the governance work properly? So it is very important to follow the procedure. What is the procedure? Simple. On what basis, on what ground the civil servant is removed, that needs to be communicated to the civil servant. That is the first and the most important one. Second, he should be given the opportunity to represent himself, to defend himself. But exceptions भी हैं. क्या exceptions हैं? अगर सिविल सर्वेंट को निकालना नेशनल सिक्योरिटी के फेवर में है, तो सिविल सर्वेंट को बिना इंक्वायरी, बिना इन्वेस्टिगेशन भी निकाला जा सकता है. So there are several exceptions which are given. So these exceptions are very important. Okay. In favor of national security, if the national security demands, the civil servant can be removed. Then, if the employee is convicted of a criminal offense, if there are criminal charges against the person, against the civil servant, then he can be removed directly. That is the second exception. And the third one is, where holding an inquiry is not practical. Let's say the person is absconding. He did something and he is nowhere to be found. In that situation, the governor or any other senior authority cannot hold an inquiry against him. So the person can be removed directly. So there are also exceptions given, but at the same time, there are also immunities given. Let's move to the second important topic. Governor of West Bengal has been charged, not charged, sort of, they cannot be charged. We are going to read Article 361, but a woman comes up and allegedly said that he has assaulted her in the Raj Bhavan. So there is something called sovereign immunity which is provided to the governors and the President of India under Article 361. What is Article 361? It originates from a very important convention or from a very important saying of the Commonwealth then that this Rex non potest pecera, that simply means the king can do no wrong. King is a sovereign body. Similarly in India, if you see president and the governors of the states, the lieutenant governors of the union territory, they all are sovereign posts. We are following the common law as well as is practiced in England. So we have taken up examples from that country regarding so many things, and one of the thing is about the governors. There is immunity provided to the governors and the president under Article 361. Okay, they cannot be treated like a criminal when they are sitting on the post. No civil charges can be initiated against them. Civil charges cannot be initiated against them. Criminal charges also cannot be initiated against the president and the governor when they are there on the post. After their retirement, the criminal charges and all those charges, the civil charges, they can be initiated. The proceedings can be initiated after their retirement, but not while they are in service. It is very important for us to understand. That is what is called sovereign immunity, which is provided to the president and which is also provided to the governors under Article 361 of the Constitution. They cannot be arrested. No criminal charges, no civil charges against them. So in one or the other way, this is also against the civil liberties. If think of a situation where a crime has been committed or something which has happened in the recent case of the governor, honorable governor of the West Bengal government. What about the person who is at the receiving end? Are they getting the justice? So this is the debate. Civil liberties on one hand, the fundamental rights of a person on one hand, the infringement of the fundamental right of the person by the governor on the other hand, and at the same time, the governor has the immunity. So is this just? Is this fair? That is the question. But that is the question for Supreme Court and the Parliament to decide. For us, what is important from the point of view of examination is Article 361. You must read it. It's very important. Moving on to the next important topic, Article 329B. So elections in India are controlled within the Constitution from Article 324 to 329. These are very important article pertaining to the elections. 324 talks about election commission, compositions and power of election commission, and how the commissioners and chief election commissioner is appointed and removed. So what is 329B? There are several things in the constitution, there are several situations where the court must not interfere. For example, inside the proceedings of houses of parliament, there is no role of Supreme Court. Everything which is done inside the houses is taken care by the speaker or by the chairman. Okay, so there are other arenas also where the court must not interfere, and one of such arena is the election process. For example, an election process is going on in your state, or a national election is going on, the Lok Sabha election. And what if you go to the Supreme Court or to the High Court and file a writ petition against the election process? Now that is not allowed. जब इलेक्शन का प्रोसेस चल रहा है, उस बीच किसी भी तरह का पिटीशन to stop or halt the free and fair delivery of elections is not allowed. Everything regarding election, if you have to go to the court, if you have to move to the court regarding any practice which you think is not fair, must be done through an election petition after the election process is over, not during that. So in one of the case, the Election Commission has invoked Article 329, and it said that judiciary must be out of the election process according to Article 329. So this becomes a very, very important part of our examination process. So electoral process has to remain uninterrupted. There shall not be any kind of interruption in the election process. This is a very, very important thing which you must understand. Rest of the things are taken care by the Representations of the People Act 1950 and 1951. 1950 talks majorly about the election process before the election, and the Representation of People Act 1951 is all about, you know, the provisions of elections, during the election and after the election, whatever which may come, any thing for which you have to move to the Election Commission of India can be taken care under these two important acts. Moving on, so what is important here? Article 329B. You must remember Article 324 to Article 329, the election process in part 15 of the Constitution. This is very important for your examination. Pay attention to this. Moving on. State can't alter the scheduled caste list. This is very important. Now, Article 341, the subcategorization, you know. So what has happened recently, the Bihar government wanted to include Tanti Tantwa caste in the list. Now, every state have some or the other scheduled castes. The scheduled castes which are there in Bihar will be different from the scheduled castes which are there in Punjab, and will be different for Telangana. Okay. So who makes these lists? Who prepares these lists? The list is prepared under Article 341. The list of all the scheduled castes, okay, is prepared by Article 341 by the President of India in consultation with the Governor of the state. So with the consultation of the Governor of Bihar, one list will be prepared for Bihar. Then with the consultation with the Governor of Punjab, the President is going to make another list for Punjab, and similarly for other states. Okay. And if any amendment has to be done in that list, means adding a caste or removing a caste from that particular list, it shall not be done by the State Legislative Assembly. It has to be done by the Parliament through law. So it is the President who prepares the list with consultation with the Governor. It is the Parliament which excludes or includes a particular caste in that list. State government does not have any power to include or exclude the castes from the list. It cannot amend the list. So the step taken by the Bihar government does not hold. It is against the Constitution. But a recent judgment of the Supreme Court talks about the subcategorization. Now that is a power which is extended to the state governments. Then that subcategorization of those castes can be done. For example, let's say if there are 59 castes in Telangana, all these 59 castes are treated as one homogeneous category. and 15% reservation which is given to the scheduled caste in India. If you know, OBC are given 27% of the reservation in employment and in education. SC is given 15%. ST is given 7.5%. So this 15% reservation which is given to the scheduled caste is given to these 59 castes which are in the list which is prepared by the President of India. Okay, and this is treated as one homogeneous category, and this 15% is applied here. But it is important for us to understand that the castes which make into this list are not equal. Many of them are socially and economically superior to the other castes, and all the benefit of these are garnered by the socially and economically benefiting castes or advanced castes. तो इस 59 castes में से those castes which are at the bottom does not get any kind of benefit of the reservation policy, and for that reason subcategorization is one tool where you can target the reservation policy and also help people who are very much marginalized and downtrodden. So these 59 castes, let's say, can be divided into 3 categories. Each of these categories would be getting some amount of reservation. Okay, let's say this is given 1%, another one is given 5%, and the last category is given 9% reservation. In total, this is 15% reservation. So this is what is called the subcategorization. Now states are empowered by the Supreme Court to subcategorize the caste. Okay, but they cannot add or subtract any caste from the list which is prepared by the President of India with consultation with the governors. Moving on to the next topic, PM Modi is talking about UCC. Under Article 44, there is a mention of UCC. It's a very important topic, Uniform Civil Code, Article number 44 of the Constitution of India. This is one of the directive principles of state policy. So what is the basis of Uniform Civil Code? There are essential practices of every religion. Okay, every religion have its essential practices, but some of the practices of every religion are of the secular nature. What are those practices? Marriage is one of them, divorce another one, adoption of child, inheritance, okay, succession, all these are secular practices. So the Uniform Civil Code tries to make same law for all the religion pertaining to these secular practices. Okay, so that is what is Uniform Civil Code. You must understand, same kind of law for all the religion. It is not trying to change the essential practices of one religion. That is not going to happen. The essential practice of the religion is going to remain intact. Article 25 comes into play here. But the secular matters revolving around inheritance, revolving around succession, marriage, adoption, all these things are very secular in nature, and similar laws can be made for them, irrespective of the religion of a person. That is what is Uniform Civil Code, and the government is trying to make a Uniform Civil Code. But there is also criticism of Uniform Civil Code. What is the criticism? That instead of making a single law for all these secular practices inside the religion, you should try to change, or you should try to amend the personal laws in such a way that it gives more civil liberty to the people. So that is the criticism which is given against the Uniform Civil Code. But in one or the other way, it is the top priority of the government to bring a civil code, a uniform civil code in the country. So this is very important, and you must understand. There are several provisions which is given. While the Supreme Court has emphasized the need for UCC in several rulings, example Shah Banu case, the Law Commission of India suggested reforming personal laws instead of full uniformity. Okay, so this is what the criticism was, and this is what the alternative which has been suggested by the Law Commission. Okay, so pluralism is one of the basic tenets of the culture in India. President Murmu rejects mercy plea of Red Fort attack case convict. So under Article 72 of the Constitution, several rights has been provided to the President. Similarly, these powers are also provided under Article 161 to the Governor of the state. So under Article 72 of the Constitution of India, the President of India can grant pardons, reprieves, respite, remission, and can commute the sentences. What kind of sentences? If it is a death sentence, the President can pardon the death sentence, but a governor cannot pardon the death sentence. You must understand this. The President has the power to pardon, reprieve, respite, commute, or remit any sentences which are given against the laws of the Union. Means all those, laws, all those punishments which have been given to the convicts, which comes under the jurisdiction of the Union government. There the President can invoke its power under Article 72 regarding the pardon, reprieve, respite, remission and commutation of the sentence. That can be done by the President. Similarly, when it is the matter of the state jurisdiction, the governor of the state can also do similar kind of functions under Article 161 of the Constitution. So this is important for your examination. You must remember, you must know this information very clearly. Okay. Now, this power is not exercised by the President or the Governor on their whims and fancies. It has to be done on the aid and advice of the Council of Ministers. That is what Article number 74 says. It has to be done on the advice of Council of Ministers. If the President has to pardon somebody's death sentence, then President cannot do this on his own. He does it on the aid and advice of the Council of Ministers. Now, why this power under Article 72 or under Article 161 has been given to the President and to the Governor? To correct any judicial incorrectness. If some judicial misconduct has happened, or judiciary has been wrong in awarding the sentence of life or through court-martial or offences against the Union and the state, then to correct that judicial mistake, this power has been given, and also to show compassion. There are many cases where the President and the Governor has shown compassion towards the person who has been convicted. So, to remove the judicial mistake and to show compassion, this power has been extended to the Honorable President and the Governor. It's important, you must remember. Neuro rights and emerging technology. See, under Article 21 of the Constitution, there are many rights which has been included. Article number 21 has become a mammoth article, right to life and personal liberty. Especially after the Maneka Gandhi case, so many things has been included under Article 21. Right to life and personal liberty. When it says life, the life cannot be only animal existence. It should be dignified life, and for dignified life, many things are important. Clean environment is important. Education is important, which has also been included in the separate article, Article 21A. It's very important. Similarly, bodily integrity is important. A woman, whether should keep the child or abort the child, that is the right of a woman, that is bodily integrity. In a similar fashion, a new kind of right is emerging. They are not written anywhere, but surely that is going to make the, the jurisdiction of Article 21 even broader. What kind of rights are these? These are neuro rights. So, neuro rights are proposed category of human rights. They are not in existence as of now, but they are proposed category of human right which protect the cognitive liberty and mental privacy. These are very important. Cognitive liberty and mental privacy with personal identity. Of course, personal identity is very important. It comes under right to privacy. Right to privacy also has become a fundamental right under Article 21 of the Constitution. So there are several laws which are there to protect the cognitive liberty and mental privacy in India. One of them is the Digital Personal Data Protection Act of 2023, Mental Health Care Act of 2017, and the Information Technology Act of 2000. So the judiciary has indirectly addressed these cases in the Puttaswamy judgment, which is the right to privacy case. It's important, okay. So there is also one case which talks about involuntary narco analysis, giving sedative to a person. वो एक बेहोश जैसी स्थिति में एक आदमी एक इंसान आ जाता है नार्को टेस्ट में, एंड देन it is presumed that whatever person is speaking is the truth. But it has to be done after taking the consent of the person. It cannot be done involuntarily. This was said by the Supreme Court in one of the cases, Selvi versus State of Karnataka. This also becomes a very important part of bodily integrity and mental privacy. Okay, cognitive liberty. That you are giving sedative to a person and making him, fall asleep or in whatever unconscious state, and then trying to extract. This is against the mental privacy of a person, and until the person is giving the consent, that must not be allowed. And freedom of thought. Now, thought definitely originates from mind. It has a direct connection with mental privacy and cognitive liberty. So, thought is also the part of speech and expression. So, cognitive liberty and mental privacy does not only become an important part of Article 21 of the Constitution, but it also becomes a very important part of Article 19 of the Constitution, where freedom of speech and expression has been given to the citizens of the country. Moving on. So, there were several political problems in Haryana, and the governor has asked for floor test. Now, what is floor test? In India, we follow the parliamentary form of government. That is a responsible form of government, where the executive is responsible to the legislature. Individual ministers are responsible to the legislature, and the Council of Ministers as a whole is also responsible to the legislature. So how to keep executive responsible? There must be some instrument, there must be some tools. And one of the tool is this. The responsibility only comes when you can form a government. Now, if a person comes up after the election, says that I am going to form a government, then at the national level, the person takes an oath as the Prime Minister, and then the President asks the person to prove the majority in the Lok Sabha. That is what is floor test. Similarly, such a thing can happen in the State Legislative Assembly also, where a person can come forward, the leader of the party can come forward, and he can speak to the governor that I am going to form the government. The governor can immediately sworn in as the chief minister, and then the person has to go and prove his majority. Can do it by his own political party or a coalition. Anything can happen. But a floor test is must. That whatever may be the majority, whatever may be the number of MLAs within the Legislative Assembly, the majority has to support the person who is standing for the post of the chief minister. And if this majority is not there, then it's a big problem. Then you cannot form the government. Then, a next person can be asked to come and attend the floor test, prove the majority and form the government. Whoever proves the majority. तो लोकतंत्र नंबर का गेम है. This is a very important thing which you must understand. अगर आपके पास नंबर्स हैं तभी आपकी सरकार बन पाएगी. तो उस नंबर को प्रूव करने के लिए फ्लोर टेस्ट होता है. Okay. Now Article 164 clause number 2 states mandating that the Council of Ministers shall hold office during the pleasure of the governor. And Article 75 and this is Article 74. Similar thing is said by the Union. Now what is this pleasure of the governor, the pleasure of the president? It simply means only when they can prove their majority in the house. अगर मनी बिल पास ना हो तो भी सरकार गिर जाती है. प्रेसिडेंट की जो स्पीच होती है टू द फर्स्ट लोकसभा, you know, the first speech of the president, which is of course being written by the council of minister, then it is put to vote. वहां पे अगर वोटिंग फेवर में नहीं होती है तो भी सरकार गिर जाती है. So there are many mechanisms where a government can fall. Okay, and it's a very important understanding about the parliamentary form of government, that it is about numbers. You have to have numbers in order to be there on the post. There has to be enough number of MLAs or enough number of MPs which has to support your claim for the chief ministerial or the prime ministerial post. There has to be a council of minister, and it's a responsible government. That is what is called the parliamentary form of government. Okay, this is how it works. So you must understand what is floor test. You must understand about Article 75 and 74, about Article 164, clause number 2. Floor test is not directly written anywhere in the constitution, but that is a term which is being given to prove the majority in the house. Opposition notice seeks removal of the chairman of Rajya Sabha. So the Vice President of India is the ex officio chairman of Rajya Sabha. Everybody have this knowledge. He is elected by both the houses of parliament. Okay, the electoral college also consists of the nominated member, which are not there in the electoral college for the election of the president. The electoral college of president is very different from the electoral college of the Vice President of India, and also the removal process is different. Now, removal of the Vice President of India can be done under Article 67B. What happens? That you have to give a 14-day prior notice and also the opportunity to the Vice President to defend himself. Once that is done, then the Rajya Sabha has to pass a resolution by the majority of the then membership of the House, whatever be the membership of the House during that time. If few seats are empty, let them remain empty. But the then membership of the House, the majority should vote in favor of the motion, and the motion is for the removal of the Vice President or the removal of the chairman, we should say, of the Rajya Sabha. And once this motion is passed, then this motion goes to the Lok Sabha, and by a simple majority, if Lok Sabha passes the resolution, the Vice President or the chairman of the Rajya Sabha is removed. So this is the simple process which you must understand. That Lok Sabha also takes part in the removal process, not by special majority but by simple majority. And it is always the Rajya Sabha which takes the lead, the majority of the then membership of the House, who must, vote in favor of the motion for the removal of the chairman of the Rajya Sabha, and he is removed. And once the position of the chairman is emptied, the vacancy is created, the next to him, the person who has been the vice chairman of the Rajya Sabha, acts as the chairman of the House. But there is no provision given that who will become the vice president. But within 60 days, 60 days, the election to the post of the Vice President has to be conducted by the Election Commission of India once the vacancy is created. So all these little provisions are very important for prelims examination. You must remember this. You must always remember this thing. So resolution with by the Rajya Sabha with an effective majority, more than 50% of the total membership, and agreed to by the simple majority of the Lok Sabha. This is an important thing. A 14-day prior notice should be given. Grounds for removal are not explicitly listed. Moving on to the next topic. Again, Election Commission of India issues notices over Model Code of Conduct. What is this Model Code of Conduct? It's a very important thing. You must study. So, recognition and registration, De-recognition of the political party. So what is the difference between recognition of the political party and registration of the political party? So registration of a political party is done under the Representations of the People's Act. Okay, under the Representation of the People Act, registration of a political party is done. But the recognition is done by the Election Commission of India. There can be two kinds of recognition which can be there. One is the recognition of a party to be a state party, and other one the recognition of the party to be a national party. And there are provisions regarding declaration of a particular party to be a state party or to be a national party. So what are these? For example, if a party gets 3% vote, total vote, and some number of MLAs, let's say 6 MLAs, then the party can be declared as a state party. If it gets 6% of the vote, okay, in the legislative assembly election or in the member of parliament election, means the Lok Sabha election, then the party can be declared as a state party. And if it is recognized as a state party in 4 different states, then it can be declared as a national party also. There's also a provision that in the Lok Sabha election, if a party gets 2% seats, according to the present Lok Sabha, if they get around 11 seats, that can be declared as a national party. So this is what is called recognition and de-recognition. That is given by the Election Commission of India. Sometimes the parties who cannot perform also loses the recognition. They also loses their symbol. They also loses their name. Many times this happens. So a party has to perform, and there are also benefits if a party is recognized as a national party or as a state party. There are benefits regarding taxation. There are benefits when a star campaigner can be there and regarding the funding of the parties. Okay, because that is a recognized party. When it comes to registration, the registration can be done. So this de-recognition can be done by Election Commission of India, but deregistration, there is no provision of deregistration by the Election Commission of India. You must understand. So if a political party has to register itself, it can register itself within 13 days of it becoming a political party. आपने एक political party बनाई, जिस दिन आपने बनाई उसके 30 दिन के अंदर तक आपको इलेक्शन कमीशन ऑफ इंडिया के पास जाके अपने आप को रजिस्टर करवाना होगा, और वो पूरी प्रोसेस होगी रिप्रेजेंटेशन ऑफ पीपल एक्ट के अकॉर्डिंग। ओके, वहां से आपको सारी चीजें जो भी प्रोसेस रहता है या जो भी चीजें which has to be given to the Election Commission of India will be told. Oath of allegiance to the Constitution of India has to be given by you in writing. There also has to be a constitution of the party which needs to be submitted to the Election Commission of India. That is the process of registration. Okay, the process of recognition and de-recognition is very different. The recognition can be there for national parties and state parties. There are few provision regarding the percentage of vote you are getting, or regarding the number of seats which you are getting in the state legislative assembly and in the national election. So this is important for you to understand. Please keep this in mind for your prelims examination. So what are the benefits of recognition? A party which is a recognized party can be a state party or a national party. It has a common symbol. It has a free airtime on TV and radio. Star campaigners are allowed. 20 star campaigners are allowed. Access to electoral roll, that is also allowed. Office allotments are also there. And tax exemption. Now tax exemption is also given to unrecognized party which are registered. So to be recognized or to be unrecognized, at least you have to be registered. A party which is not registered cannot be recognized by the Election Commission of India. सबसे पहले तो आपको register करवाना होगा Election Commission के पास according to the Representation of the People Act. Moving on to the next topic. Can Indian Parliament do what South Korea Parliament did on martial law? What is martial law? Is it defined in the Constitution? So there is no definition or explanation given in the Constitution of India for martial law. So if you see the context, following the events in South Korea, discourse arose around the martial law and its provision in the Indian Constitution. If you see the Indian Constitution, martial law is a word which is inserted under Article 34 of the Constitution of India. Now if you read the text of Article 34 closely, you will understand that it nowhere explains what is martial law. It only says that if martial law is applied, there can be some restriction to the fundamental rights. Some restriction can be to the fundamental rights for a limited period can be there when the martial law is imposed. Okay, it does not define martial law as such. So, law made under this article may curtail fundamental rights temporarily, not permanently. And this martial law can be applied to the whole of the country or to a single part or to multiple parts of the country where there is disturbance or a internal rebellion kind of a thing, or there is a war or a civil war, then martial law can be applied. So in a way we can also say that Armed Force Special Power Act 1958, although it has not been categorized as a martial law, but it is similar to the martial law where power has been provided to the authorities, to the military authorities, and the power is very extensive power, even the power to shoot. Whenever they feel as if there is some threat coming or there is some threat from the person who is a civilian, they have the power to shoot also. So, okay, these kind of powers are given to the security forces, but categorically, Armed Force Special Power Act is not under the martial law. Martial law is different, okay, which is there, sort of this word is inserted under Article 34, but although not defined. So, the action must relate to maintaining or restoring of the public order, and the declaration and the scope of martial law remains undefined in the Constitution. अगर आपने उसके, you can also be indemnified. That simply means if you do something to protect the peace in the country during the martial law, then some positive things can be done for you by the Parliament. That is also a provision under Article 34. If you read the text of the article, that is a very beautiful text, but it does not define anywhere what is martial law. So, okay, it is a bit different from what has happened in South Korea. Only temporarily fundamental rights can be curtailed during martial law in India. Moving on to next important topic. Citizenship Amendment Act. Rules are notified. Now, what is this Citizenship Amendment Act? So, Article 5 to 11 relates to the citizenship in the Constitution of India. That is part number 2. But whatever is written under Article 5 to Article number 11 ends and in a way is restricted till the commencement of the Constitution. So, on the commencement of the Constitution, who will become the citizen of India has been told by Article 5 to Article number 11. Although the Parliament is given the power to bring a statute, to bring a law which defines the future course of citizenship in India. And in 1955, the Citizenship Act was enacted by the Parliament. That act has been amended several times. In 1985, it was amended. In 2002 also, it was amended. So recently in 2019, the Citizenship Act was amended. So Citizenship Amendment Act of 2019. It was heavily criticized. There was violence on road also. There was riots also in Delhi. What are the provisions of the Citizenship Amendment Act of 2019? That persecuted minority from 6 different religions except Islam, from 3 different countries, Afghanistan, Pakistan and Bangladesh. So persecuted minority from these three countries. And what these minorities can be? They can be Hindus, they can be Christians, they can be Sikhs, Parsis, Jains, Buddhists, these six. If they are persecuted in these three countries, Pakistan, Afghanistan and Bangladesh, they can enter India and they can get a fast track citizenship. Anybody who has entered India before 2014 December has already got the citizenship of India. But they must be from these six religions, which are minority in the three countries of Afghanistan, Pakistan and Bangladesh, and also they must show in some or the other way that they were persecuted minorities there. So the rules to implement the Citizenship Amendment Act of 2019 has been brought by the government. What are these rules? Online application is there. So a person who wants to enter India, want to become the part of India, the process of naturalization has been decreased to 5 years. Anybody who have already entered India before 2014 is already been given the citizenship. To apply for citizenship, there is an online application process. That is what is written in the rules. The next thing which is written is the district and state level committee for verification and certification. So there are two levels. The district level and the state level committees are there for verification, whether the person who is coming belongs from the three countries or not, or belongs from the persecuted minority or not. Some kind of data has to be there, some kind of verification has to be there. That verification is done on two levels, at the district level and at the state level. Then requirement of proof of religious persecution or fear thereof. You just want to enter India and become the citizen of India, and that is the reason you have changed your religion to either Sikhism or Hinduism or any other religion, and then you enter India. Now there has to be some kind of verification. Okay, and you have to also prove that you belong to a persecuted minority. You cannot cheat the authorities by changing your religion and then coming to India and trying to become the citizen of India. That also has to be verified. So there has to be some kind of proof of religious persecution. Also, there will be verification at the state level and at the national level. The oath of allegiance to the Indian Constitution. This is very important. If you are entering in India, you want to become the citizen of India, you should show the intent to be the citizen of India, and that intention is reflected when you show your allegiance to the Constitution of India. It is very important. Citizenship certification through digital means. So the whole process has been digitalized. That is what the rules for the Citizenship Amendment Act 2019 says. They are very, very important. So the rules operationalize under Article 11, which empowers Parliament to regulate citizenship. So from Article number 5 to Article number 11, Part 2 of the Constitution of India talks about citizenship, and under Article 11 it is the Parliament which can make law on citizenship, since single citizenship is there in India. We do not have dual citizenship like the United States, where there is different citizenship. There is a national citizenship and there is a state citizenship. In India there is only one single citizenship, the Indian citizens. And the laws regarding those Indian citizenship is made by the Parliament. And Article 11 empowers the Parliament to make these laws. Okay. So Parliament to regulate citizenship. However, the implementation excludes 6th scheduled areas and inner line permit regions for the preservation of their local autonomy and culture. So this rule, these particular rules, the Amendment Act is applied to whole of India except the 6th scheduled areas and the inner line permit. Now, what is 6th schedule? So the tribal areas from 4 states, Assam, Tripura, Meghalaya and Mizoram, are covered under 6th schedule. These are the tribal areas where you will find the autonomous councils, and the autonomous councils, they govern those areas. The governor of the state holds immense power in those areas. Okay, and the CAA 2019 and the rules thereof does not implement to these 6th scheduled areas. Also to inner line permit areas. What is inner line permit? That is a kind of permit to visit that area. The inner line permit, I think, was there in Manipur, that if you have to enter that particular area, you need this permit. You cannot enter without the permit. So to protect their autonomy and to protect their culture, the CAA rules are not applied to these areas. So you can get a question in your prelims examination that CAA rules are applied to which area, which region? To the whole of India, to the whole of India except Schedule 6 areas, whole of India except Schedule 5 areas, whole of India except the inner line permit area. You have to mark this correctly, and you can only mark that correctly when you know the provisions. Provisions are very simple, that it is applied to the whole of India except the 6th scheduled areas and the inner line permit areas. Now, moving on to the next important topic. Supreme Court verdict on subclassification of scheduled caste and scheduled tribe. We have already seen Article 341 in one of the slides, that Punjab was trying to add a particular community in the list which is prepared by the President of India with the consultation of the governor and can only be amended by the Parliament. So what has happened here? Subclassification or subcategorization under Article 341 of the Constitution of India. It is important. So the power to make the list of the scheduled caste is given to the President. President, in consultation with the governor, make the list for different states. We have seen this already. Then to amend that list, the power is given to the Parliament. The state assemblies as such, the state government does not have any specific power with regard to the making of the list or amending of that list. Okay. But the recent judgment of the Supreme Court has extended this power of subcategorization or subclassification to the states. The Devender Singh versus the state of Punjab, this was the case, a very important case in which the subcategorization of scheduled castes and of scheduled tribes were allowed, and Telangana recently has become the first state in the history of India to subclassify or subcategorize the scheduled castes. So again, trying to understand from the example of Telangana, there were 59 castes which became which formed the list or which formed the homogeneous category of scheduled castes. There were 59 castes, okay. These 59 castes were given 15% reservation, which is extended to the scheduled castes. Till here it is clear. Now, what is subcategorization is that these 59 castes which are treated as homogeneous castes, they are further divided into 3 categories. Okay. And 1% reservation is given to this category, 5% is given to the second category, and 9% is given to the third category. In this way, those which are the most marginalized and downtrodden caste among these 59 also gets the benefit of reservation. That is where the subclassification of subcategorization of the scheduled castes comes into play. Or there would be perpetual inequality in the society. The very purpose of the reservation would fail if the subcategorization is not there. Those were the words of the Supreme Court. So it is important to subcategorize, and this power of subcategorization has been given to the state government, and Telangana has become the first state to do so. Erstwhile, Andhra Pradesh has also tried it once in the year 2000. Okay, but that was overturned by the Supreme Court, but now the Supreme Court has agreed to it, agreed for the subclassification. Now, subclassification or subcategorization is allowed for OBC category according to the Indra Shawnee case of 1993. There is also a provision of creamy layer in OBC which is not found in the SCs and STs. Okay. Moving on to the next topic. Delimitation Commission, a very important thing in news nowadays. Why? Because 2026 is coming, and according to the changing population, the boundaries of the constituencies needs to be changed, and for that there has to be a Delimitation Commission. So if you see Article 82 of the Constitution of India, 83 of the Constitution of India, this talks about the tenure. This talks about 83 about the jurisdiction or the boundary. So after every 10 years, after the census, a Delimitation Commission must come into play. To understand this in a very simple word, what is delimitation? This is the simple exercise of changing the boundaries of the constituencies. The constituencies can be the constituencies for the member of parliament and the member of legislative assembly. So what does the Delimitation Commission do? First is, with the changing population, it changes the boundaries of the constituencies. And that has to be done according to the Constitution of India after every 10 years, after the census. Because in census, the population of the country is calculated. And you know, after the calculation of the population of the country, delimitation should happen. That is the idea of fair representation. Okay, the fair representation can only happen when there is some kind of ratio which is maintained in representation. That happens through the delimitation exercise. The second important thing is the allocation of the seats. For example, the allocation of the seats in Lok Sabha from different states. That is also done on the basis of the recommendation of Delimitation Commission. So it is very important. So it has to be done after every 10 years. But this was freezed. Okay. The recent, the present Lok Sabha, which contains around 545 people, 543 member of legislative assemblies, that was done on the basis of 1971 census. The population of India, which was there in 1971, according to that, the boundaries of the legislative assemblies and the boundaries of the parliament, the members of the parliament, the constituencies for the members of the parliament has been made, has been drawn out by the Delimitation Commission based on the census of 1971. In 1976, by the 42nd Constitutional Amendment Act, which is a very important Constitutional Amendment Act, many of the provisions which were brought by the 42nd Constitutional Amendment Act were overturned by the 44th Amendment Act in 1978. So according to 42nd Constitutional Amendment Act, the allocation of seats to the Parliament has been freezed till the year 2000. And in the year 2000, it was further freezed till 2026. Now 2026 is here. We are already in 2025. So there has to be a Delimitation Commission, and the population has changed drastically. The recent 2011 census has to come into play, and a Delimitation Commission has to be established by the Parliament to look into the changing of the boundaries of the constituencies for the member of Parliament and for the member of the Lok Sabha. So what is happening? If you see, what has happened from 1976 or 1971 till now, the population of the northern state has increased tremendously, and the population of the southern state has been contained by them through family planning and through several policies. So, in a way, the southern states are penalized. They have followed the law, they have followed the process of family planning. They have done everything to reduce or to contain the population, and now they are being penalized. So the southern state are feeling like they have been cheated. So something has to be done, because if you compare the population of the northern Indian states such as Uttar Pradesh, which is going to get huge number of seats because of its huge population, whereas the states of Tamil Nadu and Kerala and the other southern state are not going to get that much seats, even comparatively that much seats. Why? Because of the less population, because the Delimitation Commission takes its decision to make the boundaries on the basis of the population of the state. Okay, so this is a big question which has come up again. So you must understand the basic nitty-gritty of what Delimitation Commission is under Article 82 Lok Sabha and 170 for the state legislative assemblies. So Lok Sabha election recently took place in 2024. Several things have come up. So the context of this news is that the Lok Sabha election were held amid calls for reform in nomination rules, in campaign conduct and in vote counting. तो ये मुद्दा तो बहुत पुराना चल रहा है, वीवीपैट वाला, वीवीपैट. So in one of the case, this वीवीपैट, it was, the petition was to implement the वीवीपैट throughout the country in the election, but citing some practical reasons, Supreme Court has said that VVPAT cannot be applied to the full country, to the whole country in the election process. So now it is not applied everywhere. This was basically to check whether the machine in which you cast your vote, is it working perfectly or not. So if you go and cast your vote, and if you have cast your vote to, let's say, party number A, there is party B, C, D, E, and you have given your vote to party number A, then you are going to get a slip also, the verification slip, which says that yes, the vote which I have given to party number A, the slip is the same of the party number A, not of party number B, C or D. This proves that the machine is working properly. Okay, so that is what the VVPAT was, but now it cannot be implemented throughout the country according to the ruling of the Supreme Court. So these are some articles which you should keep in mind. 324 tells the powers of the Election Commission of India. 326 talks about universal adult suffrage, that everybody above the age of 18 years and the citizen of India should be enrolled to give votes, should be enrolled in the electoral roll. Article 325 and 326. 329B, we have already seen, it bars the judiciary from interfering in the election process, a very important article for the free and fair election process to take place. Some kind of institutional integrity has to be maintained, and for that reason this particular article to bar the judiciary in the election process has been implemented or has been inserted in the Constitution. The Representation of the People Act 51 for nomination, campaign and disqualification rules. So as we have already seen, the Representation of the People Act 1951 is about the election process, during the election process and after the election. And the Act, the Representation of the People Act 1950 majorly deals with issue before the election. So there are concerns and doubts in the mind of students regarding these two different act of representation. So Representation of People Act 1950 deals with all the topics which should be contained before the elections, and the Representation of the People Act 1951 deals with all the topics which should be dealt with during the election process or after the election process. So EVM machines, to check whether the EVM machine is working properly or not, VVPAT was used, but then it cannot be used throughout the country, citing the practical reason by the Supreme Court. and the model code of conduct. It's a very important thing. It is not written anywhere. It does not form the part of anything, but in a way, all the political parties sort of implement, or sort of, although it is implemented by the Election Commission of India, but the acceptance is shown by all the political party. It's the convention to show respect to the model code of conduct in India before election. It is there to regulate political behaviors during election, that all the developmental works must stop, all the freebies and other kind of gifts which the political parties give to the citizen to woo them to vote in their favor must stop during this model code of conduct. Also, the issue of simultaneous election comes into play here, because simultaneous election is going to save too much of time, because in model code of conduct too much time is wasted and the developmental work is stalled or hampered. And because of that, if the election, the assembly election and the national election takes place only once in 5 years, in that one confined period, then a lot much time and energy and money could be saved, and the developmental work could go on forever till the next period comes. So the model code of conduct is also linked with the simultaneous election process. We'll see it. Supreme Court overruled the 1967 verdict against the Aligarh Muslim University's minority tag. So Aligarh Muslim University, you must understand about this. First thing is, article number 30 gives the right to the minority to establish institution, educational institution. Okay, there are several rights which are given to the minority, the linguistic minority or the religious minority. There are two kinds of minority which are being mentioned under article 30 of the constitution, and these minority can establish the educational institutes. Okay, so Aligarh Muslim University was not a university. It had become a university in 1920, but it was established in 1875 by Sir Syed Ahmad Khan as Mohammedan Anglo-Oriental College. So this was a college. Aligarh Muslim University becomes a university in 1920 by the Aligarh Muslim University Act in 1920. In 1967, a petition was filed in the Supreme Court, and the Supreme Court ruled that it is not Aligarh Muslim University is not a minority educational institute, because it was initiated by the Aligarh Muslim University Act of 1920, Aziz Basha case. So this case has snatched the minority educational institution, minority status of Aligarh Muslim University. That happened in 1967. In 1981 again, an act was passed declaring Aligarh Muslim University as a minority educational institution. But again, a petition was filed against this act, and the Allahabad High Court has turned down its minority status. Now what happened after 1981? Recently, again a petition was filed, and this time Supreme Court has ruled over the decision or the judgment of the Allahabad High Court and the decision or the judgment of the Aziz Basha case in 1967, providing Aligarh Muslim University the minority status. There are several conditions which are also being told by the Supreme Court, and the Supreme Court also said that if an institution is initiated by the minority community, then it should get the minority status, and it is not necessary whether it is getting the statutory status by the Government Act. Still it can be called as a minority educational institution. Okay, if this particular university is initiated by the minority community. So of course Aligarh Muslim University was initiated by the minority community, minority Muslim community. It although became a central university under the AMU Act of 1920, but it does not become the ground to declare it a central university and snatch its minority status. So simply Supreme Court said that if educational institution has been established or is initiated by a minority community, it should remain a minority educational institution despite of it being given a statute or a statutory status by some act of the parliament or the state legislature. This is what is the case of Aligarh Muslim University. Article 30 is very important here. Aziz Basha case is very important here, and minority status is very important term which you should understand. There are also several benefits if an institution is a minority institution. Although under Article 29, Clause 2, there shall not be any discrimination on the basis of religion, race, caste, language for the admission of the people. Some kind of reservation is although given in the Minority Education Institute, but that there shall not be any discrimination. So, okay, students of other religion can also study in Aligarh Muslim University. When a university has a minority status, it does not mean that only the students of those community are going to study there. Okay. Moving on to the next slide. Why Bombay High Court said use of loudspeaker is not essential to religion. So essential practices, we have already seen this in one of the previous slides. Essential religious practice doctrine. This is a test which is applied to everything. It is also applied to loudspeakers. So loudspeakers have become a very important part of religion, a very important part of Hindu religion, a very important part of Muslim religion also. But is the usage of loudspeaker a essential practice, a essential religious practice or not? It is not. That is where the rule or the doctrine of essential religious practice comes into play. There has to be a test which must be applied to check whether certain practice which is done by a particular religion forms the part of the essential core practice of that religion or not. This essential practice test has been applied to animal sacrifices. It is also applied to entry of women, temple entry, and to the environment also. So Article 25 gives the right to a person to propagate, profess, practice his religion. But there are also several conditions which are applied. Condition of morality which is there, of decency which is there. Those are the reasonable restrictions. Also, there is another thing which is called as the ERP, the Essential Religious Practice Doctrine, or the test which is taken. For example, if a particular religion does not allow women to enter into temples or into dargahs, then is it the important religious practice of that particular religion or not? That is checked by the Supreme Court through this doctrine, through this test. And if it is not the religious practice, then it should not be followed. Rather, what should be followed? Civil liberty. Article 14, Article 19, Article 25. Okay. So I hope you are getting, this is the fight between fundamental rights on one hand and essential practices of religion on the other hand. You have your right under Article 25 to practice, profess, and your religion, whichever religion it is, within the confines of the law. But at the same time, if you are using loudspeakers, does that also form the part of the essential religious practices or not? And if not, then it must not be used. Why? Because it is in one or the other way infringing upon the fundamental rights of the citizens. Article 21. You have the right to sleep. That is a very important aspect of right to life and personal liberty. Existence should not be like animal or there shall not be animal existence. There has to be some kind of dignified existence, dignified life. And how can there be dignified life if you do not have the right to sleep properly? And there will not be any right to sleep if you play loudspeaker all night. Why? Because you think that it is the essential practice followed by the religion. Although the court takes the test, and if that particular practice does not pass the essential religious practice test, then the practice should be turned down. So this is the important article which you must understand for your examination. Moving on to the next, preventive detention. Now, preventive detention cannot be misused for law and order issues. That is what is said by the Supreme Court. Now, article number 22, protection against arrest and detention, that mentions preventive detention in clause number 3. Preventive detention, it is presumed or on the assumption that a person can cause harm to the law and order situation, the person is taken into custody. That is what is preventive detention. And the person can be kept in custody for about 3 months. And after 3 months, there is an advisory board which takes decision whether the person should be there in the custody or not. And if the advisory board, which consists of judges, allows the further detention of a person, then the detention can be further increased beyond 3 months. But at that time, the person has to be told the grounds on which he is arrested. He must also be given the legal representation. All these things has to be done. And while telling or communicating the grounds or the charges on which the person is elected, or the person is detained, any sensitive information must not be given. And any law regarding preventive detention has to be made by the Parliament. So now what the code is saying here, the preventive detention amendment and judicial scrutiny highlighted concerns around misuse of preventive detention. So preventive detention is a great power in the hands of the executive to confine or arrest somebody on grounds which they not necessarily be telling to the people. But what comes into play here? Who protects the civil liberties here? It is the judiciary. So judicial review is very important in preventive detention cases. And preventive detention cases must be used justly, in a fair manner, non-arbitrary manner, because it infringes upon the liberty of the person. Think about a situation. In normal terms, if a person is arrested, immediately the person has to be told about the grounds on which the person is arrested. Immediately a legal representation has to be given. If he is taken to some XYZ place, the kins and the nearby family members has to be communicated the location where the person has been taken. Also, the person has to be presented in front of a magistrate within 24 hours. But in the case of preventive detention, none of this thing applies. So a person can practically be kept in the jail for 3 months without even telling on what charges the person is there, or without even giving the legal representation. But with different cases and the overreach of the executive on the civil liberties, the court is coming up and saying that the charges has to be communicated, the charges must be due, they must be fair, they must be non-arbitrary, and a legal representation must be given. So, in a nutshell, we can say that preventive detention should not be misused. So, right to information and the exemption. Right to information is a very important piece of legislation. It, in some or the other way, it provides the basis for good governance in the country. If you get the information of whatever is happening in the governance, what kind of expenditure is done, expenditure if done, has been done in which way, in which manner, if a tender has been given, what is the process, due process is followed or not, the planning was done correctly or not, all these things are very important to keep a check on the executive power, to hold them accountable for whatever they are doing, the executive. It is very important. It's a very, very important piece of legislation. But several changes are made recently, such as in the data protection law. Also, an amendment was made after the Right to Privacy Act, that the name of a person, the name of the official shall not be disclosed under the Right to Information Act. For example, you make a application for something, and the time limit which is given, there's also something called Citizen Charter, which tells that a particular service has to be provided in how many days or how many months. It gives the list that this particular service will be provided in 1 day, this will be done in 1 hour, this will be done in 5 months, all these things. So if you make, for example, you make an application and your application is stuck at some place, you could practically file a right to information petition, and you can extract the information about the person who is not passing, or on whose desk your file is stuck. You can ask about the authority, the position of the authority, and the name of the authority, which the authorities have to give under the Right to Information Act. They were legally bound to give, but now the name will not be given. So many things have been done to the Right to Information Act, which forms the basis of the good governance in this country. So Right to Information Act of 2005 empowers citizens to access information from public authority, reinforcing transparency and accountability. So several sections are there, like section number 4, suo motu disclosure of information. So if you are going to become a civil servant tomorrow, and let's say you are a secretary of a particular department, of a particular ministry, for example, under section 4 you have to make public some information, okay, so that the number of RTIs, number of right to information petitions which are coming in, the applications which are coming in, are going to decrease. So suo motu disclosure of information is a very important part of right to information. But there are several exemptions which are also given. There are grounds given in section number 8 of this particular act. Grounds for exception, like national security. If there is some information regarding national security, it must not be disclosed. Trade secrets must not be disclosed. Personal information must not be disclosed. That's what we have seen under section 8. That earlier, when you used to ask for the name of the person who is sitting on your file, that was provided to you, but now it will not be provided. So the jurisdiction of the Right to Information Act has been further reduced. Okay. Section 24. It exempts certain intelligence and security organizations such as IB, such as RAW. Okay. The information on corruption and human right violation is allowed. This is important. Not all the information is allowed, but if information is related to corruption, information is related to human right violation, that kind of information will be allowed under RTI. Moving on, FCRA registration of 5 NGOs cancelled by Ministry of Home Affairs for violation of law. Now, Foreign Contribution Regulation Act. The act itself says foreign contribution. That simply means the contribution is coming not from within the country, but the contribution is coming from outside the country. Okay. Now, what kind of contribution can come? Contribution can come in the form of money, in the form of technology, and there can be contribution in many ways, but precisely in the form of money. To whom the contribution can come? To the civil society, to the NGOs, to civil society. Now, civil society, non-governmental organization, they form a very important part of the governance process. I am saying not governance, governance process. How? Because those civil society are the spokesperson for the rights of the people. Okay, there are several civil societies which are working in the areas of education, of health, of entrepreneurship, public safety, and women empowerment, child protection, for old people. All these civil societies are there. Think about a situation when these civil societies are getting money from some foreign country, and that foreign country is giving them money, and in return it is trying to implement its own agenda in India. Now that is illegal. And it happens that several civil societies which are getting funding from some foreign countries are also running their agenda in India. If there is some law or legislation which the parliament does not want to bring, these civil society stand up to oppose the government. Why? Because their funders which are sitting in the foreign countries are saying so. Because if that particular law or the provision of law is brought by the parliament, it is going to benefit them, the funders who are sitting outside the country. So such a thing must not happen. There shall not be any kind of manipulation of the elected government in India by some foreign country, or by some sources or funders sitting in the foreign country. So to stop that, several tests has been made. Okay, so that is what is the FCRA Act. The government suspended or cancelled licenses of several NGOs. So FCRA 2010 regulation, it regulates the foreign donation made by the foreign nationals to the civil society in India, to ensure they do not affect the internal security or the democratic governance in the country. So it mandates several things. What does it mandate? Registration and prior permission for accepting foreign fundings. That if you want some kind of foreign funding, you should take prior permission from the government, and government is going to see what kind of activity you do and who is funding you. Okay, then only you can avail that funding. Disclosure of the bank account and the utilization of the bank account. Where is your bank branch situated? Now see, in 2020, further regulations were further tightened. What happened was, the government prohibited sub-granting to other organization. That simply means, if let's say this is a organization which is getting this is the civil society which is getting foreign funding, and it gets, let's say, $10 million. It keeps $5 million and distributes other 5 to 4 other civil societies, or 4 other institutions, or 4 other NGOs. This subletting, this sort of sub-granting is not allowed. Okay? If the foreign contribution is given to this particular organization, this organization must keep it and use it for its own use, but not after. It can only happen after the government sees from where the funding is coming and where is your bank account situated. And it has also tightened this one more thing, that your bank account has to be situated in a SBI branch in New Delhi. So the government has mandated opening of the FCRA account in SBI New Delhi. So the foreign funding which is going to come to India will only come in your SBI account whose branch is there somewhere in New Delhi. After that, you can transfer, you can have multiple accounts, and you can transfer that money in those multiple accounts. But the source from where it is coming, from where the money is flowing, it should come only in one bank account. And that bank account has to be there in SBI, this is a nationalized bank, and its branch has to be there in New Delhi. Now that is further tightening of the regulation. And the expenses on the administration will be limited to 20% of the total fund. So to stop corruption, because too much money is brought, and sometimes these organizations claim that administration of these organizations take a huge amount of cost. So okay, it must not go beyond 20%. Although they claim, but that money is used somewhere else. For that reason, the government has limited the administrative expenses to only 20%. So I hope you are getting what FCRA is. Bills on simultaneous election to Lok Sabha and State Assembly. We have already seen this in the previous slide related to a model code of conduct. So simultaneous election, one nation, one election, proposes synchronized polls for Parliament and State Assembly to reduce frequent election cycles and associated costs. So several constitutional changes have to be made for simultaneous election. Article 82A has to be inserted. There is no Article 82A as of now in the Constitution, but it has to be inserted to empower the Election Commission to conduct simultaneous polls. So as already discussed before, Article 82 and 83 are very important. 83 talks about the term of Lok Sabha and also of Rajya Sabha, which is a continuous house. It does not have any term. It does not get dissolved, but 2/3 of its member get retired after a time period. But Lok Sabha, it has a time period of 5 years. This is the natural time period of Lok Sabha, which is there under Article 83. So amendment has to be made under Article 83 relating to the Lok Sabha and under Article 172 relating to the State Legislative Assembly to define unexpired term and provide continuity. Amendment to Article 327 granting Parliament enhanced power to legislate on elections. So we have seen Article 324 to 327 talks about the elections in the country. So 327 gives the power to the Parliament to make law regarding the election process in the country. Okay, so it's a very important provision of the Constitution of India. So insertion of Article 18(2)(a), more power given to Parliament under Article 327 and more power to Election Commission after the definition of unexpired term. So for example, to make it more simple for you, let's say one election, Lok Sabha election plus the State Legislative Assembly election have taken place in month of May in 2024. Similarly, 6 months before, state legislative assemblies have gone for election in the year 2023 in the month of December. So these two dates are 6 months apart, but around 5 to 6 state legislative assembly have seen elections in the December of 2023 and around 5 to 6 legislative assembly have seen election along with the Lok Sabha election in the May of 2024. Okay. So 2 times model code of conduct has to be applied, 2 times the cycle of election has to be there, the electoral roll has to be adjusted, the whole Election Commission of India starts to work, so many employees, especially the teachers and other staff goes to duty. So why not all this thing can happen in one go? That all the states in India, Lok Sabha election plus all the states in India, their elections happen in one go. That is what is called one nation, one election, simultaneous election. Simultaneous election means election of legislative assembly and state, all these states together. So you have to go and cast your vote for member of parliament and at the same time you have to cast your vote for member of legislative assembly. So much time, energy, so much money can be saved. But to bring this law, this thing, several changes has to be made. This unexpired term has to be explained. That for the first time when such a provision has to come, okay, this 6 months have to be covered up. That the next election is going to be there in 2029. If May 2029 is taken as a date of simultaneous election, then what about these state assemblies? Because their due date for election would be somewhere in 2028 in the month of December. Will they be there for 6 more months? That is to be seen. And there are other concerns also. What if no party is able to prove its majority? What if the governor's rule, or to say the presidential rule under Article 356 is applied? All these things are major concern. Then the simultaneous election may become a failure in future. Those are the concerns. But for us, for now, it is important to understand Article 82, Article 83, Article 172 and Article 327 under Part 15 of the Constitution. 2 lakh plus nota votes in Indore. Now, none of the above option is a very important option. Many of you, I am sure, must have casted your vote on the nota. Let's say there are several names and nota comes at last. These are the names of the candidate who are fighting the election. And if you press nota, then the vote goes to nota. But it does not have any legal implication. If in any constituency, in any state legislative assembly election or a parliamentary election, nota wins, then the runner-up, the person who is second, is declared as a winner. So nota as such does not have any legal implication, which in the opinion of many people is a very bad thing. It must not happen. But several states have come up. They have shown interest, such as Maharashtra, such as Haryana, is now trying to implement nota very seriously in the local polls. State legislative assembly make rules and regulation related to the elections of panchayat and elections of municipality. So they are trying to bring nota as another candidate. So nota will be a different candidate altogether. That simply means if this candidate wins, if nota wins, then the election are going to take place again. It is going to give some authority to none of the above option. It is going to tell to the candidates that the people have chosen none of you, and you must do something that the people start to choose you rather than choosing nota over your name. So it is very important, and this kind of self-reflection must be there in political parties, it must be there in the candidates. It is starting from the local level. It's a good thing. Maybe we can see this option becoming legal, becoming impactful in the national election and in the state elections as well. Who knows? So can a candidate contest from 2 seats in Lok Sabha? Section 33, clause number 7 of the Representation of the People Act of 1951 allows for it. So you must have seen Prime Minister Narendra Modi. He fought from 2 seats in one of the Lok Sabha election, from Varanasi and from Vadodara. Rahul Gandhi, he fought from Wayanad and also from another seat of Raebareli. So a person can fight election from 2 seats, but there are criticisms related with it, because the person has to leave 1 seat and choose 1 seat. So what about the electoral viewpoint? People have given vote to that particular candidate to win. What about the decision made by the people? That is the reason why this twin candidature is criticized. And several law commission, see this law commission 170th and 255th report, and also the Election Commission of India has recommended limiting candidacy to only 1 seat. But let's say when this is going to happen. Okay, it does give some political flexibility, and it is a strategic tool in uncertain constituencies. Also, important campaigners or important party leaders such as the Prime Minister himself has to be elected. So it gives a certain kind of added protection that if the person loses from one constituency, at least he wins from the other constituency. But again, there are problems. It is a burden on exchequer. It undermines the voters' mandate. Okay, it's a problem. The Kerala Centre dispute over states' borrowing powers. So state can borrow under Article 293. Under Article 292, the centre also can borrow. So what kind of borrowing can be there? So if you see Article 293, the states can borrow on their own. They can fix their limit and they can borrow on their own, keeping consolidated fund of the state as a security, as a guarantee. Okay, they can also borrow, the states can also borrow on the guarantee of the consolidated fund of India. पर अगर किसी भी तरह का बैकलॉग है, कुछ भी आपने लोन ले रखा है स्टेट ने, and there is some due which is left, then the parliament may not allow it to borrow or reduce the limit, certain limit of borrowing. So that is what was done. Dispute over tax distribution in borrowing limits. Kerala's borrowing cap under Article 293 was reduced by the central government or the parliament. So this is a very important article, 293, along with it 292, which talks about the borrowing capacity of the central government, and 293 talks about the borrowing capacity of the state government. This is a very important article. You must remember this for your upcoming examination. Tax distribution done by Finance Commission under Article 280. Article 270 allows devolution of net tax proceeds, which went up to 42%, and after the establishment of Jammu and Kashmir as the the union territory, it has reduced to 41%. You must remember, this is an important provision. New criminal laws, a paradigm shift in legal framework. If you see the erstwhile Evidence Act, the procedure code, the criminal procedure code, and the Indian Penal Code has been reenacted, has been changed a bit, and new laws giving new names, Bharati Nyaya Samhita, Bharati Nagrik Suraksha Samhita, they have been made by the Parliament in 2023. So BNS has replaced IPC, Indian Penal Code. Bharati Nagrik Suraksha Samhita has replaced CRPC, and Bharatiya Saksh Samhita Adhiniyam has replaced the Indian Evidence Act. So some changes has also been done. Some simplification of language has been done. Categorization of offences has been done in a more nicer and a simpler manner. Along with it, emphasis on the crimes against women and children has been the center point of the new this replacement of the Indian Penal Code, which is the Bharati Nyaya Samhita. Along with it, sedition law under 142A was repealed, and it is replaced by provision on acts endangering sovereignty. Now, mob lynching and organized crime are also being recognized under the Bharati Nyaya Samhita. Separately recognized, they have been made as a distinct offense which was missing under IPC 1860. And the enhanced role of technology in investigation has been accepted. So these three important law, BNS, BNSS and Saksh Adhiniyam, in Bharatiya Saksh Adhiniyam, are the cornerstone of criminal justice system in India. They are very important law. So we have completed 25 topics. Hello students, welcome to Sriram's IAS, welcome to this class. This is a live class of Indian Polity Current Affairs, which is going to help you in your upcoming prelims examination. And we are going to see several current affair topics from last year and from this year, and we are going to study about the static part. Before we start, congratulations to all the people who have made to the final list, who have become officers this year. Today the result of UPSC was declared. Hearty congratulations from Sriram's IAS to you all. And let's begin our class. So this is a current affair class presented by me. I am Mayank Bhardwaj. Let us take the first topic. It is about the doctrine of curvature. What is this doctrine of curvature? You know, male and female, they are two different legal entities, isn't it? Every individual have their own dignity. Every individual have their own capacity. Every individual have their own standing. Legal standing also, individual social standing also, economic standing also. भाई आपका आधार कार्ड बनता है तो वो सबकी आइडेंटिटी बताता है ना, वोटर कार्ड बनता है वो हर एक इंडिविजुअल की आइडेंटिटी बताता है. बट दिस डॉक्ट्रिन सेज दैट आफ्टर मैरिज द लीगल आइडेंटिटी ऑफ अ वुमन was subsumed in the legal identity of a man. Means they both were treated as one legal person. So this is the legal identity of a woman. It was intact before marriage, but after marriage it was subsumed by the legal identity of a man. Man here is the husband. Now of course this is very patriarchal kind of law which was used in England. It is one of the doctrine of the common laws. India follows common law, but India does not follow this particular doctrine. It should not be used, and it is not used because it infringes the fundamental right of individuals here in India. Article 14, right to equality. Women have equal right like men. Article 21, right to life and personal liberty. She has a life. And when I say life, it is the dignified life. It is not some animal existence. Repeatedly told by Supreme Court in several of its orders. Then Article 15 prohibits discrimination on the basis of religion, race, caste, sex, place of birth. So on the basis of gender also you cannot discriminate. So how can you use this particular doctrine in today's India, today's democratic India? It is not possible. But it was in current affairs. It was seen somewhere. Judicial commentary and academic debates have reignited discussions around the archaic doctrine of coverture and its relevance to gender justice. It is not used in India because it infringes upon several articles. So if UPSC asks you in prelims examination, what is this doctrine? I hope you will be able to answer it now. Let's see a little bit about it. It is a British common law, not used in India, and I am pretty much sure it is also not used in Britain now. So it was used in colonial era or before that. A married woman's legal identity is subsumed under her husband's identity. किसी भी महिला को कुछ rights अगर ना देने हो, for example inheritance के rights, litigation के rights, तो ये आप डॉक्ट्रिन यूज करवा सकते हैं. Okay, inheritance can only happen when a woman has a legal identity of her own, have a social standing of her own. But if her identity is subsumed in that of her husband, how can she be a different person? She is not treated as a different person if this particular doctrine is applied. So I hope you have got the bigger idea of what doctrine of curvature is all about. Let's move to the next topic. This is a different doctrine which is a very useful doctrine, and Supreme Court uses it for positive things, harmonious construction. So there are several provisions of the Constitution. What if two provisions are conflicted? One provision is in conflict with other. For example, there are fundamental rights, and the fundamental rights must not be breached by the actions of the state or by the policies made by the legislature. It's a simple understanding. But what if the state has to implement the directive principles of state policy? And in order to implement the directive principle of state policy, some of the fundamental rights are infringed. Which of the provisions should stand? So to not nullify any of the provision, to not declare one of the provision as redundant and inoperative, Supreme Court uses the doctrine of harmonious construction, that the harmony must be maintained between two provisions. Okay, and both the provision shall not be inoperative but should be working. But if there is any special law, the special law must get priority over the normal law. Okay, so with example we can understand, if let's say this is Article 31C, which sort of a exception, okay, it was added later on, it was not there in the original constitution, it was added later on by different amendments. 31A, 31B, both these were added by the first Constitutional Amendment Act in 1952, and this was added later on in the 25th Constitutional Amendment Act in 1971. What does it say? That if any action is taken by the executive or by the parliament to implement the directive principles of state policy written under Article 39B and 39C, and if there is an infringement of any fundamental right, especially the fundamental right of equality and fundamental right of freedom, Article 14 and Article 19. So if any action of the government while it is trying to implement the directive principle of state policy given under this particular article infringes Article 14 or Article 19, then that infringement shall not stand. That simply means that nobody can move court on the ground that fundamental rights of equality and freedom is breached by the action of the executive or by the law or the policy made by the parliament, when the executive or the parliament are trying to implement the directive principle of state policy given under Article 39B and 39C. 39B, 39C पे थोड़े दिन पहले जजमेंट भी आया था. प्राइवेट प्रॉपर्टी क्या होती है इसके ऊपर, क्या प्राइवेट प्रॉपर्टी को कम्युनिटी की प्रॉपर्टी माना जा सकता है कि नहीं, और अगर माना जा सकता है तो कम्युनिटी की प्रॉपर्टी जो है उसका इक्वल डिस्ट्रीब्यूशन होना चाहिए. So for example, if your property is taken up by the government and is declared as a community property, it will be distributed among all equally. The fruits of that, the resources and all the earnings through that property will be distributed equally. So Supreme Court said that you cannot declare any property as a community property. You cannot take the private property of a person and declare it as a community property. Okay. Of course, there are, properties which belong to a person but have wider national and social use that can be declared as a community property and can be distributed among everybody equally, but not all the private properties. So, I hope you are getting what is harmonious construction. If I am sounding too legal, I am going to make you understand in a very simple language. अगर कोई fundamental right और कोई डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी के बीच में कॉन्फ्लिक्ट है, या तो फंडामेंटल राइट इंप्लीमेंट हो सकता है या डायरेक्टिव प्रिंसिपल इंप्लीमेंट हो सकता है, दोनों एक साथ इंप्लीमेंट नहीं हो सकते. देयर इज अ कॉन्फ्लिक्ट. व्हाट इज द स्टेप टू बी टेकन? जो भी चीज स्पेशल है, जो भी चीज वाइडर गुड के लिए है, दैट विल बी गिवन प्रेसिडेंस. इस केस में एक्सप्लिसिटली मेंशन्ड है आर्टिकल 31C के अंदर कि किसी भी तरह का कानूनी कार्रवाई नहीं होगा अगर डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी को लागू किया जाता है, और सिर्फ वही डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी जो आर्टिकल 39 के क्लॉज बी और क्लॉज सी में लिखी हुई है, कोई भी दूसरी डायरेक्टिव प्रिंसिपल नहीं. सो दैट इज व्हाट इज हार्मोनियस कंस्ट्रक्शन. हार्मोनियस कंस्ट्रक्शन सिंपली मीन्स दैट नन ऑफ दीज प्रोविजन which are conflicting in nature, they are conflicting in nature, isn't it? So none of these provisions will be inoperative. None of them will be redundant. None of them will be declared as null and void. Both will be working together. And there will be harmony between these two provisions. Okay, I hope you got it. Let's move to the next topic. Mission Karma Yogi. So this is the capacity building program of Government of India. कैपेसिटी बिल्डिंग, किसकी कैपेसिटी बिल्डिंग हो रही है? सिविल सर्विसेज की कैपेसिटी बिल्डिंग हो रही है. पहले ग्रेड ए तक के ऑफिसर्स की कैपेसिटी बिल्डिंग हो रही थी सर्विसेज में ऑफिसर्स की. अब its scope has been increased and included the mid-level and state bureaucracy also. So what is the basic idea behind this Karma Yogi scheme? To build the capacity, of course, but with what vision? The present government is trying to turn the vision of the bureaucracy from rule-based to role-based. This is something which you should understand. From rule-based to role-based. There are many schemes and policies of the government which are very effective if implemented properly. But the point is that bureaucracy is unable to implement it properly for the reason that there are too many rules and regulation and procedures to be followed. Now, if too many procedures are to be followed, too many rules are to be followed, the soul of that particular policy dies. The implementation is delayed, the implementation is not 100%, and the effectiveness is also not 100%. So what is the meaning of such a policy? You make a policy और वो बस rules और regulations और procedures में ही फंसी रह गई. Just to avoid this shift in vision is there from rule based to role based. Okay, I hope you are getting it. It's a program of the government for capacity building. There are several features such as creation of I got Karma Yogi platform for digital learning. और ऑफिसर्स सीखेंगे ये सब, ये जनता के लिए नहीं है. Encourages behavioral, functional and domain competencies. अगर आपका environment पे पकड़ बहुत अच्छी है, if you know very deeply about the economical issues, then that competency has to be used by the government. And if you are the officer, let's say you are an IAS officer who has very good grip over the economic subjects, or very good grip over the social aspects, or very good grip over the environmental aspects, then you will be used, your competencies will be used in that particular direction. Okay. Covers all government employees across departments. So it's a very positive move. It is going to improve the efficiency of the governance. आप वो काम करने में आपको फायदा मिलेगा, मौका भी मिलेगा जिसमें आपको इंटरेस्ट है, जिसमें आप अच्छे हैं. गवर्नमेंट भी रिकॉग्नाइज करेगी आपकी कॉम्पिटेंसी, and then will allow you to work in that particular department. So it's a long program, and we do not know the details of it, but yeah, it is being implemented by the government of India in its own way. Anchored by the Capacity Building Commission. This is one new commission under PM's HR Council. Prime Minister का Human Resource Council भी है. So you should see this, and it's a homework. Try to find out whether it's a statutory body or not. Government fiat से आया था, या statutory body है, या constitutional body है, या HR Council क्या है? And similarly कैपेसिटी बिल्डिंग कमीशन, इसका भी आप पता करके बताइए, कमेंट सेक्शन में लिखकर बताना. मूविंग ऑन टू द नेक्स्ट टॉपिक, इंपॉर्टेंट टॉपिक, नेशनल ह्यूमन राइट कमीशन. नेशनल ह्यूमन राइट कमीशन इज अ स्टैट्यूटरी बॉडी इन इंडिया. ओके, इट इज अ वेरी इंपॉर्टेंट बॉडी. इट ट्राइज टू प्रोटेक्ट द ह्यूमन राइट्स इन इंडिया, इट ट्राइज टू प्रमोट द ह्यूमन राइट्स इन इंडिया. बट इसकी जो रैंकिंग है वो अभी गिरा दी गई है. किसने गिराया है? लेट्स सी. There is a global alliance of national human rights institution, Ganhari. It's a global alliance of national human right institution. इसने जो A रैंकिंग दी हुई थी, नेशनल ह्यूमन राइट कमीशन, इंडिया का जो ह्यूमन राइट कमीशन है, उसकी रैंकिंग को नीचे कर दिया है. And why is this happening? Because in a way, if you see, the National Human Rights Commission in India is toothless. It cannot do anything except investigating in human right violations, and after that it just asks the government to do something. So basically there are too many capacity issues with it. There are other issues such as political appointments, inadequate representation of civil societies. There are delays and backlogs in grievance redressal. One more provision is there that if any human right violation has taken place and the reporting of that human right violation takes 1 year or beyond, the National Human Rights Commission is not going to entertain that. So such provisions are sort of making the National Human Rights Commission a toothless body. It is a non-cooperative body. It just sits and it investigates a little. Its findings are also not taken up properly or are implemented. Its recommendations also are not implemented properly. There are too many problems such as political appointment problems, inadequacy in representation and delays in backlogs. So you must understand that this particular body, National Human Rights Commission, is a statutory body, and it was established in 1983 by National Human Rights, 93 by National Human Rights Act. So there are, if you see the composition of National Human Rights Commission, there's a chairman plus maximum there can be 8 members in this commission. 50% of the people here would be coming from judiciary, plus 50% of the people will be coming from the marginalized societies such as SCs, STs, OBCs, minorities and women. Okay. Moving on to the next topic. 10 states withdraw general consent to CBI to investigate cases. Now, you know India is a quasi-federal state. The federalism issues are in India are many, because India is neither perfectly unitary state nor perfectly federal state. Perfectly unitary state like the Great Britain or perfectly federal state like the United States of America. India is somewhere in between. But the power is tilted towards the center. There are many provisions, such as the governor, who is appointed by the central government, who represents the central government and is also a head of the state government. So there are many provisions in the Constitution of India which sort of makes India a quasi-judicial state. Also the emergency provisions, if you see, it makes the country perfectly unitary when emergency is applied. So now what has happened with CBI? Now Central Bureau of Investigation is a special body in India, and special investigating body in India, which was established through the Delhi Special Police Act in 1946, and it investigates important cases. Cases which are very high volume, cases which are very important for the socio-economic conditions of the country, and it's a top class investigating agency. Although in past it was also said as a parrot in cage. That is a very derogatory way the terms were used, but that was the truth, because the government uses this CBI for its own benefit. Now the same allegations have been put on Enforcement Directorate, that the government is using these body against the oppositions. It can be the civil society opposition or can be the political opposition. Okay, anyway, so this body was established under the Delhi Special Police Establishment Act in 1946, and it works as a central agency in several states. So the India is a federal country also, so consent of the states will be required, because law and order, investigation, police, everything is there in the state list. But there is a central agency who is going into a state and trying to investigate. So some kind of consent will be required from the state government, isn't it? Now that consent is of two types. One is the blanket consent which is given by everybody to the Central Bureau of Investigation agency, and the other is for the specific cases. But recently what has happened, those consent were withdrawn by 10 states, that we are not allowing the CBI to come and investigate in our states. You look at the context. West Bengal and Punjab have withdrawn general consent for CBI investigation, limiting its operational scope. Now, it's a big news. It also shows the failure of efficient working and harmonious working and cooperative federalism. So we often use this word cooperative federalism, but there is no cooperation when it comes to such an important issue such as CBI and its operation in different states. So this is something which we must understand, and it can be a very important issue for your upcoming examination. So Supreme Court in state of West Bengal versus the Committee for Protection of Democratic Rights, this was a case of 2010, has upheld CBI's jurisdiction in court-monitored cases, but emphasized federal respect. So federal respect has to be shown. Just because CBI is a very big body, it's a very efficient body, it's a top body for investigation, that does not mean that the federal structure of the country has to be in any or the other way compromised. The consent of the state government is required. The consent has to be taken, and then only the CBI can work. Also those cases which are monitored by the Supreme Court itself. Abhi RG Kar medical college rape case was there. It was monitored by the Supreme Court directly, and also the CBI was monitoring it. Now that is one of the case. In such cases, the operation of CBI is very much valid. But you must understand for your prelims examination, when this CBI was established, what is the composition of the CBI? Is it a constitutional body or not? Is it a statutory body or not? It does become a statutory body because it is established by a statute, by a law brought by the parliament. Okay. It gets its powers from this Delhi Special Police Establishment Act of 1946. Okay. And there are concerns relating to federalism. So a question can be asked, and you should be in the position to give the answer. Moving on to the next topic, Lokpal. Now after CBI, another important body, Lokpal. Lokpal and Lokayukt Act was implemented in the year 2013. There was a huge movement in Delhi, Anna Hazare movement, India against corruption movement, and after that the parliament passed the law for the Lokpal and Lokayukt Act, and Lokpal was implemented established as a body at the national level, and Lokpal in different states to investigate into the cases of corruption. So it is a powerful body. In a way, if you see, jurisdiction of Lokpal stretches to Prime Minister. So it can investigate Prime Minister also, to ministers, MPs, Group A and Group B officers. Now you will say that there are no president and governors. We have read yesterday about Article 361, which gives immunity to both president and governor, which is also called as sovereign immunity. And there can not be any kind of cases, either civil or criminal, which can be filed against the president and the governor when they are sitting on their post, when they are serving their tenure. You must understand, Prime Minister comes under the jurisdiction of Lokpal, ministers come, MPs come, Member of Parliaments, Member of Legislative Assemblies, Group A officer, Group B officer. Also the Lokpal can direct the CBI for investigation. It's a very important aspect. And complaints can be made by any citizen. Means I or you can go and make a complaint against a particular officer who is a corrupt officer, and you have found out something. You can be a whistleblower in your own department or company or anywhere. You can also go and file corruption charges against the Chief Minister or the Prime Minister. Any citizen of India can file it. Okay, so it's a powerful body. But now what is the problem here? What is happening? If you see, there is lack of appointments, means there are vacancies and the vacancies are not filled. Low case disposal because of lack of appointments. Then insufficient resources, and it is diluting its power. These are the major lacunas which can be seen in the Lokpal Anti-Corruption Act. Okay. And Lokpal was very important when it comes to realizing Article 14 and Article 21 of the Constitution. Right to life and personal liberty, dignified life. You must have a good governance around you. The government which is taking care of its citizen must not be corrupt, at least should not be corrupt. And for that reason, the Lokpal Anti-Corruption Act was passed. Also, the corruption at the basic level, at the bottom, grassroots level was the big problem. आपको एक बर्थ सर्टिफिकेट बनवाना है, आपको एक डेथ सर्टिफिकेट बनवाना है, आपको टांग दिया जाता था या आपसे रिश्वत ली जाती थी. ठीक है, तो इन सब को कवर अप करने के लिए लोकपाल एंड लोकायुक्त एक्ट वाज पास्ड. बट नाउ इफ यू सी lack of appointment, low case disposal and insufficient resources, it tells the story of what is happening with this Lokpal Act. So moving on to the next topic, before that you must understand it's a statutory body, Lokpal and Lokayukt Act of 2013. यहाँ से आइए, you must understand it's a very important body. Supreme Court in a majority verdict upholds constitutional validity of EWS quota. Now EWS quota is for the general classes. So we have several classes, isn't it? Scheduled castes, scheduled tribes, other backward classes, socially and educationally backward classes, and there is general class. Okay, so the poor people of general class, or the people of general class who were not economically sound or were economically weaker, were given 10% quota in employment and in educational institution. Okay, so this EWS quota was extended to the general class. So petition was filed in the Supreme Court, and it was said that this particular EWS quota must also be extended to scheduled caste, scheduled tribes and OBC. And if it is not extended to these classes, it infringes the basic structure of the Constitution. Supreme Court in its judgment said that not extending EWS quota to scheduled caste, scheduled tribe or OBC does not infringe the basic structure of the Constitution. Okay, it's a very important provision which you should understand, that EWS quota is applied to general category, 10% of reservation, which is over and above of 49.5% reservation, which is extended for SCs, STs and OBCs. OBC get 27%, ST get 7.5% and SCs get 15% in employment and in education. Where is the provision? EWS. If you see article number 15, clause number 6. Okay, article 15 prohibits discrimination on several grounds, on the grounds of religion, race, caste, sex, place of birth. But there are several exceptions also. Special provisions can be made for other backward classes, for economically and for socially and educationally backward classes. Special status, special provisions can be made for women and children. Special provisions can also be made for SCs and STs. In the similar fashion, special provision of reservation can also be made for economically weaker section in the general classes. And over and above this 49.5%, a 10% reservation is also given. So the 50% limit, the ceiling limit which was fixed by the Supreme Court, people think that 50% ceiling by the Supreme Court was done for all the kind of reservation, but that's not true. 15% ceiling limit is only for the reservation which are extended to SCs, STs and OBCs. This is only for 15 clause 4 and 16 clause 4. 15% limit is not there for EWS, and EWS holds legal sanctity. Article 15 clause number 6 gives it the legal backing. So EWS, it is very much constitutional. That is what the Supreme Court has said. And even if it is not extended to SCs, STs and OBCs, it is not the violation of basic structure. Moving on to the next important topic, need of the hour. What is the need of the hour? Is to raise OBC category creamy layer income limit. Now this was also a case. Something was there in the current affairs section. You know about the Indira Shawnee case, and through Indira Shawnee case, subcategorization of the OBC was allowed. Also a creamy layer concept was introduced. What is this creamy layer concept? that OBCs get 27% of the reservation in education and employment, isn't it? Out of this 27% reservation and OBC, there are many categories which are socially and educationally and economically well-off communities. They are so much developed that their social standing or their caste has no impact on their way of life. Those are the people who come under creamy layer. And there are some economic provisions made for who can be the person in creamy layer. Anybody who is earning, whose family earning is less than 8 lakh rupee, this is the person which should not be. No, this was the provision for EWS. I'm sorry, I've forgotten. Who could be the person in the EWS? EWS. Anybody whose family income is less than 8 lakh rupee. So less than 8 lakh family income. If the family is holding a flat, the area of the flat must not be more than 1000 square feet. That's the second requirement. 1000 square feet and less. And if the family is holding a farm, the area of the farm must not be more than 5 acres. Okay. So this is what EWS category is all about. All the people who fulfill these criteria come under EWS. Now moving on to the creamy layer thing. So this creamy layer is there. And this 27% reservation which is given to the OBC is not given to the people who are there in the creamy layers. Okay. Creamy layer को SCs and STs के लिए भी implement करने के लिए बातें चल रही हैं, but अभी तक implemented नहीं है. But it was implemented by Indra Shawnee case. This creamy layer concept was implemented for OBCs, and 27% reservation is not applied to the people who are coming in creamy layer. Now, what is the problem here? Recent court ruling and commissions have reignited the debate on defining and revising the income criteria for OBC, creamy layer. कि इसको बदलो, इसको चेंज करो. So the present income threshold is 8 lakh per annum, okay, subject to revision. And several people are saying that it must be revised. Okay. It's a very important concept under Article 15, clause number 4, which gives the state the power to make special provision for socially and educationally backward classes. Under this, the reservation is extended. 27% of the reservation is extended to the OBC in education and in employment. Similarly, 16, clause number 4. So I hope you have understood this. अभी बातें चल रही हैं. अभी क्रीमी लेयर में कुछ चेंज नहीं किया है. क्रीमी लेयर की डेफिनेशन जो थी वो वही है. Okay, but people are saying that it must be changed. Some change must be brought to the creamy layer definition. What is Article 371? Now everybody have heard about Article 370 and its abrogation by the Jammu and Kashmir Reorganization Act of 2019. Article 371 is a different thing altogether. Article 371, if you see, is the permanent article, permanent feature of the Constitution of India. Whereas Article 370, which was abrogated by the Jammu Kashmir Reorganization Act of 2019, was not the permanent feature. It was a temporary feature. If you see, it was implemented in 1950 by the presidential order. Okay, somewhere in 1950 or 1954 by the presidential order. It was not a permanent feature, but Article 370 is the permanent feature. It gives several special status to several states, especially the northeastern states. It has helped the northeastern state a lot to preserve their culture, to preserve their autonomy, to preserve jobs, everything. This thing has helped. 371 has especially helped the northeastern state. Also to bring them into the mainstream society. Article 371 is very important. So the focus on regional autonomy has brought renewed attention to Article 371. Now Article 371 and its subclauses are there from A to G, and several states are included in it, grants special provision to specific states like Maharashtra, Gujarat, Nagaland, and especially the northeastern state. It protects the indigenous culture, it ensures local job and land rights, and it facilitates equitable development. So this is a very, very important article, you must understand. These provisions uphold cooperative federalism and meant to address historical and regional disparity. Now if there were disparities, of course there were disparities. Okay, the people living in the tribal areas or people living in a particular state, let's say Maharashtra, but there are several pockets where people were not in the mainstream. In order to bring those people into the mainstream, some protection needs to be provided. That protection was provided by Article 371. I hope you are getting it. So that is what happens with Article 371, special provision for several states, especially the northeastern state. Moving on to the next. So CAA, again in news, not to be implemented in most tribal areas in northeastern state. Citizenship Amendment Act of 2019 was not implemented in the areas of 6th schedule and the areas where inner line permit is required. ILP, inner line permit, is required. So what is this 6th schedule? This is very important for you. The 6th schedule have several states such as Assam, Tripura, Meghalaya, Mizoram, and it also have autonomous bodies, autonomous districts, regional districts. That is the special provision for these 4 states. These 4 states are not covered under the scheduled areas which are there under schedule number 5. These are tribal areas. Governor holds a lot of power here. There are also autonomous districts and regional districts, and they also have judicial power of their own to constitute courts which have the civil and the criminal jurisdictions to help the population to solve their problems of law and order. So they do have this autonomous thing. Why? Again, to protect their culture, to protect their autonomy, to protect their way of life. If they are just mixed in the normal mainstream society, their uniqueness will be diluted. That was the problem with coming of the Britishers in India. If you see, majority of the issues of Britishers against the tribal people, the fights were because of the reason why Britishers used to intrude in these tribal areas and use their resources and exploit their resources, which these people, the tribal people, does not like. So after the commencement of the constitution, and the constitution also carries those provisions which protects their autonomy, which protects their uniqueness. And for that, several autonomous districts are made. For that, regional councils are made. Autonomous districts, the people, there's 30 people are there who are elected, and they look after the administration of these districts. Governor again holds a lot much of power. So these councils are constitutionally empowered under Article 244, clause number 2. You must understand this. For the tribal identity to be intact, it has to be implemented. And you must understand this one logic, which is a very simple logic, that CAA of 2019, the amendment which was made to the Citizenship Act. Now, Citizenship Act came in 1955. Provisions were already there from Article 5 to Article number 11 in the Constitution of India. This is part number 2 of the Constitution. But these provision only tells who would be the citizen of India on the commencement of the Constitution. इसमें जितने भी प्रोविजन दिए गए हैं वो सिर्फ यही बताते थे कि 26 जनवरी 1950 को इंडिया का सिटीजन कौन है. उसके बाद की जो भी चीजें थी were left on the Parliament, and Parliament has came up with the Citizenship Act of 1955. Now the Citizenship Act have been amended so many times. It was amended in 1985 also, it was amended in 2002 also, and recently it was amended in 2019 also, to allow the persecuted minorities, which does not involve Islamic communities or Muslims, from 3 different countries to enter India and get citizenship of India very easily. A sort of fast track citizenship has been given to these communities from 3 countries, Afghanistan, Pakistan and Bangladesh. And this particular amendment does not apply to 6th scheduled areas and inner line permit areas. Should voter ID be linked with Aadhaar? Now Aadhaar is linked with everything. आधार का आपके बैंक अकाउंट से लिंकेज है, आधार का आपके वोटर आईडी से लिंकेज है. It raises some kind of privacy issues. So this is the fight between privacy on one hand and linkages with Aadhaar, the efficiency which government wants to bring on the other hand. Why so many datas are linked? There are concerns of privacy. What if surveillances are there? What if our data is leaked? What if linking of several different ID cards or ID card with bank account can result in some kind of problem? There are many things which can happen. So on one hand, after the Puttaswamy judgment of 2017, which upholded right to privacy and said that right to privacy is the fundamental right, several things have changed in India, and one of them is the linkages of Aadhaar with different things. So in the ruling of Supreme Court, it is said that it is not mandatory to link Aadhaar with your bank account. This is not mandatory. Now what will be mandatory? If you are a beneficiary of a welfare scheme, then you have to give your Aadhaar. Then you have to link your Aadhaar. But if you are not a beneficiary of a welfare scheme by government, it is not needed to link your Aadhaar with your bank account. So that is basically what has happened. You must understand what is Aadhaar. It's a 12-digit biometric based identity. It is not a proof of citizenship of India. You must understand. Anybody who is living in India for a particular period of time can get Aadhaar card, and it does not provide citizenship. Citizenship is a different thing altogether. Enables DBT, direct benefit transfer to beneficiaries. Voluntary in nature but functionally mandatory in various services. Now what are these various services? Welfare schemes of the government of India. And after Puttaswamy case, we have already seen it is not mandatory to link your bank accounts and telecom services with Aadhaar, but permissible for welfare schemes. Okay. Article 21, right to privacy on one hand, right to equality on one hand, and governance and efficiency of governance on the other hand. Because linkages of Aadhaar, Trinity, JAM, and linking Aadhaar with bank and linking Aadhaar with telecom services and other things improves the efficiency of governance. But it also raises some privacy concerns. 75th Constitution Day, history and significance of 26th of November 1949, hereby we adopt, enact and give to ourselves this constitution. So the Constitution of India was adopted and enacted on this day. It was adopted by the Constituent Assembly. Enacted means it was passed as a law by the Constituent Assembly. And the preamble starts with we the people. And the last it says we give this constitution to ourselves. So to celebrate 26th of November 1949, we celebrate it as Constitution Day, and this was the 75th Constitution Day. Constitution is something which is holding this country together. It is based on the principle of constitutionalism, which means limited government. Okay. Supreme Court also has been coming up with judgment which is stretching the civil liberties in all the areas. If you see the mammoth shape which Article 21 has taken, those are very important provisions of the Constitution. And on this 75th day, Constitution Day, what is important for us in this particular article. What is really important for us is to understand the preamble very closely. What has happened on which date? What has happened on 26th of January 1950? What has happened on 26th of November 1949? When was the Constituent Assembly started working? When was the Constituent Assembly ended its work? When was the national flag and national anthem were adopted? All these historical dates you must remember. And at the same time, you must also see the special features of the Constitution of India which are not found anywhere. If you see, where will you see the basic structure doctrine? It's not found anywhere. Where would you see the preventive detention? It has been included in the fundamental rights. It is not used, not in United States, not in the Great Britain, in the way it can be used by the government in India. So it's one of the special features, the basic structure, the quasi-federal nature of the Indian Constitution. The fundamental duties, rarely you will find fundamental duties in any constitution around the world. So all these special features of the Constitution of India which is not found anywhere, you must remember this. Maybe UPSC can ask this because it is the 75th Constitution Day. You must remember the dates as well. What are the issues around delimitation? Now, there are several issues around delimitation. We are going to see what. Delimitation Commission and electoral justice. Now this Delimitation Commission is there. Must be constituted by the government after every 10 years. This is what the provision is. Article number 82 is involved. So what is the purpose of establishment of the Delimitation Commission? To redraw the boundary of the constituencies. So there are boundaries in India. We have a parliamentary form of government. We all know that we go and cast our votes. That is how the member of parliament are elected and the member of legislative assemblies are elected. Okay, the member of parliament does have a jurisdiction. And then, somebody who is a member of parliament of other jurisdiction does not interfere in this jurisdiction. So there is a boundary that people of that particular constituency will go and vote for different people. So I hope I am making sense here. If this is the state, it is divided in several constituencies. Okay. There can be many constituencies within the state. Similarly, if this is a big country like India, it is also divided in different constituencies. So people living in that constituency or are registered in the electoral roll of that constituency go and vote for the particular person who are standing for the elections. Now this number of constituencies which are there, it was done on the basis of 1971 census for states and for national level also. And then in 1971, the next commission came in 2002, and this Delimitation Commission has fixed or freezed the number of constituencies which were already there at that time till 2026. Now we are in 2025 and 2026 is coming. So it becomes mandatory to establish a Delimitation Commission which is going to redefine the boundaries, and the boundaries are redefined on the basis of population. आपको थोड़ा और सरल करके अगर मैं बताऊं तो मान लीजिए ये एक कॉन्स्टिट्यूएंसी है, इधर पहले 15 लाख लोग होते थे. ओके, बट अब इस कॉन्स्टिट्यूएंसी में 25 लाख लोग हो गए हैं बिकॉज पॉपुलेशन बढ़ गई है. 25 lakh people are there. So don't you think these must be redefined? That one person was representing 15 lakh people is now representing 25 lakh people. And population increase is not same everywhere. In India also, if you see the southern state for implementation of the family planning and other things, the southern states are at loss. This is one of the important thing or important criticism which is coming out from the Delimitation Commission exercise. That the representation of the southern state in the Lok Sabha is going to decrease. And the reason for that would be the less population rate of the southern state. Because the population increase of the northern state is far higher. The state of Uttar Pradesh, according to the present calculation, would get seats more than 140 seats. Presently it has 80 seats in the Lok Sabha. So if the delimitation exercise is based only on the population, if the present formula is used, then the northern state will get more representation in Lok Sabha, whereas the southern state will be at loss. This is one of the controversy. Also controversy is coming from the northeastern state, that because of the delimitation exercises, several tribal groups have been excluded or included, which is disturbing the balance. So there are too many things and too many problems related to the Delimitation Commission. So the formula needs to be changed, or the seats will be further freezed for another decade or 2 decades, like it was done in 2002, and the seats were freezed, number of constituencies were freezed till 2026. It is yet to come. The information is yet to come. Government has not taken any decision on what the Delimitation Commission is going to do, and what will be the recommendation of these Delimitation Commission, and what will be the formula on which the Delimitation Commission is going to redraw its boundaries. The boundaries of the constituencies of member of legislative assemblies and the member of parliament. So basically it was dependent on population. There can be other reasons also. Now other criteria can be included. Okay. EVM and VVPAT case. What are the key takeaways from the Supreme Court's verdict? So this VVPAT, why was this implemented? In order to check whether the EVM machine is working properly or not. That was the basic idea behind this VVPAT thing. There was a physical verification by VVPAT that it was a verified slip, voter verifiable paper audit trail. That simply means if you will go to cast your vote, आप बूथ में गए, आपने अपना वोट कास्ट करा, जिस भी पार्टी को आपने वोट दिया ईवीएम मशीन में, साथ में एक स्लिप निकलेगी, और अगर उस स्लिप में उसी ही पार्टी का नाम है जिसको आपने वोट दिया ईवीएम मशीन पे, that simply means that EVM machine is working properly. Just to see whether the EVM machine works properly or not, this VVPAT was introduced. This was a way to shut those voices who were questioning the EVM machine, Now, it was implemented on one booth in one constituency. So in one constituency, it was implemented in one booth. That one particular booth would be taken, and this VVPAT thing, this verification will be done in that particular booth. अगर उस booth पर आपका electoral roll में नाम है, that simply means you will go and cast your vote, and also you will get a slip, which will be physical verification of whether the machine is working properly or not. There were concerns, and this one booth was increased to 5 booths. That simply means this VVPAT verification will be done on 5 booths in one constituency. This happened after the 2013 judgment of the Supreme Court in Subramaniam Swamy versus Election Commission of India. Now several people are saying that 5 booths in one constituency constitutes only 1% of votes. Hence, this VVPAT exercise must be implemented throughout the country. Supreme Court said that it's not possible. How can it be implemented throughout the country? There are several concerns. The election will be delayed. Election mechanism will be disturbed. At the same time, there is no capacity to do this. Huge risks has to be taken. And there can be other kind of problems as well. So Supreme Court turned down this particular request made that the VVPAT should be implemented throughout the country, and hence it was in news. You must understand the basic ideas behind it. So it brings transparency in voting process. It makes the voting process independent, and the capability to audit the election process becomes very simple, and it reduces electoral fraud perception. But to implement it on a nationwide level or a statewide level would be a bigger problem for Election Commission and for the government. Moving on to the next important thing. Delaying local body polls cost Karnataka rupees 2.8 thousand crore. Local body polls. So local body polls simply means the election to the panchayats and municipalities. Now India is a democracy, and after 73rd and 74th Amendment Act, the democracy was taken to the grassroots level. That even in panchayat elections will be there, for municipalities election would be there. And who is the body? Which is the body which is going to conduct these elections? So the State Election Commission became that body under Article 243K and under Article 243ZA. The panchayat and municipal elections were conducted, and this body was constituted. But this body also needs finances. This body also needs different resources. This body also needs capacity building, needs people to work for it. And all these things are not happening. So the grassroots election process, the grassroots democracy is suffering. On one hand, Maharashtra government and Punjab government are trying to make Nota, none of the above option, as one of the candidate. That simply means it is going to give more effectiveness to the Nota option, that if the Nota option wins, then a re-election will take place. So on one hand, these kind of ambitious ideas are brought forward by the Maharashtra government and the Punjab government, but at the same time, there are also news that state election commissions are not given appropriate resources to work properly. And this was the news from Karnataka. So, what are the challenges? Interference from state government. The government always interferes. The local level bodies are not working very properly. They're not working in a democratic way it should. Lack of autonomy is there. Lack of infrastructure is there. And delayed election, undermining grassroots governance. So all the law which are made for the state elections, means the elections of the municipalities and the elections of the panchayat, are made by the state legislature, and it is the state legislature which is responsible for interfering in this process. Interference in the constitutional body, State Election Commission, interference in the election process, interference in so many other things, and not properly sort of giving resources to this particular body to work and implement the democratic values at the grassroots level. It's an important article for you to understand. 73rd and 74th Amendment, it shows sort of failure towards those amendments. Moving on to the next one. Mediation opens door for creative solution. What is this mediation? It's an alternate dispute resolution mechanism. Arbitration, mediation. So in 2023, to make this mediation process more better, more efficient, more voluntary, an act was passed which was called as the Mediation Act. Okay. To formalize the alternate dispute resolution through pre-litigation mediation. The Act institutionalized mediation as a time-bound mechanism. Okay, this is a time-bound mechanism. This is not going to go on forever. There has to be some time limit to it. That if a case has to come to the court in the pre-litigation stage, the parties must go to a mediator. And there are several mediating facilities which are available in different courts. If you go to courts in Delhi, Tees Hazari Court or other courts, you will see those mediation centers there. And this process is totally voluntary. If a person wants to file a case against a party, then it can be done. But the judge always tells to go to the mediating center first. This reduces the burden on the judiciary, reduces the number of cases which are pending. It's a very important process. If followed properly, it followed in a formalized manner, then it is going to reduce the number of cases which are pending in the judiciary, the backlog, the the vacancies and everything. It is going to be of some use. So this act was institutionalized as a time-bound exercise. It's a voluntary exercise and a confidential process that the information is not going to leak. And several key features are also there of this Mediation Act of 2023. That it becomes mandatory pre-litigation mediation. So in several cases, pre-mediation has been made mandatory. Not in murder cases or rape cases, which are cases of high volume, the cognizant matters. Police has to take cognizance. The court has to take cognizance. Those are serious matters. In that, there is no mediation which can happen. That's the crime against the state. That is sort of crime against the society. So a case has to be filed. The mediations are done in PT cases or cases which are not of very high volume, which is not a murder or a homicide or a triple murder or a rape case or things like that. Those do not go into the mediation center. Those are crimes against the state. Those are crimes against the society. So it needs to be tried in the court of law, not in the mediation center. But there are many cases, civil matters, smaller criminal matters, family matters, financial matters, which can be solved in mediation center through the alternative dispute resolution mechanism. I hope you are getting this. Establishment of Mediation Council of India. So there was no Mediation Council of India, and now this will be established under this particular act. Recognition of online mediation and enforceability of mediated settlement. So if you see Article 39A, equal access to justice to all, it is going to help. This Mediation Act is going to help. It is also going to reduce the judicial backlog and aligning with the global alternate dispute resolution processes. Fast track courts dispose 94% of the cases of sexual offences. So fast track courts have been established by the government, and it has done phenomenal work. If you see the cases under the POSCO Act or cases relating to rape in section 376 of the IPC were solved by these fast track special courts. Okay, so this is a very important thing which has happened. And these court, what does they do? They reduces the pendency, deliver a time bound justice, and enhances the judicial sensitivity to vulnerable groups. So special provisions can be made for women and children under Article 15, also under Article 16. So this is one of the provision to provide them justice, in such a way that the justice is not delayed, and the society should become sensitive towards these vulnerable sections, towards women, towards children, and hence the establishment of fast track special courts, which in a way is very fastly trying to dispose of the cases. The investigation done by the police is also a matter of concern, because the investigation done properly by the police and the forensic helps the judiciary to solve the cases in a more efficient manner. Okay, so this is one of the things about the fast track cases. If it has been asked, so you can give the answer. The Gram Nyayalaya Act of 2008. Now the Gram Nyayalaya Act is also there. What does this do? It is established under the Gram Nyayalaya Act. There are several Gram Nyayalayas which are established. They do have the criminal jurisdiction and the civil jurisdiction. So you see, we have the democracy at the grassroots level, elections for panchayat, elections for municipality. So there must also be a ground level grassroots judiciary, and Gram Nyayalaya is one of that. Gram Nyayalayas are implemented or established or has legal backing under the Gram Nyayalaya Act of 2008. And the aim is very simple: accessible, affordable and swift justice. Jurisdiction, as we have discussed, civil dispute, petty offences. And procedure will be informal, flexible and locally rooted. Now we are trying to understand the system which was prevalent in India before the Britishers came here. The justice system of India was like this only. Gram Nyayalayas were there who could solve the cases in a very informal and flexible manner. Local laws were implemented. Religious laws and social laws were implemented. Customs were also implemented. We have included everything now in the Constitution. If you see the definition of law under article number 13, customs are also there, which are included, along with rules, regulations, notifications, ordinances. Customs are also there. So customs, social customs, religious customs, they were the laws which were there already in existence before the coming of the British and before they made the modern legal system in India, which became very expensive for Indians. Sort of it was the failure of the justice system after the Britishers came here. That system which we are continuing till today was not working properly in the initial stages. And today we have learned the lesson and we are trying to implement the Gram Nyayalayas under the Gram Nyayalaya Act. And this is one of the provision which reminds you of what was going on before the Britishers came. There were Gram Nyayalayas. They used to work in an informal way, but they were very impactful. They were very efficient. The justice were delivered immediately by them. Okay, the process is coming back, and thanks to the government for realizing and implementing the Gram Nyayalaya Act. And this was done in 2008. Remember this. This was in news and question can be asked. Demand for inner line permit. Now what is this inner line permit? We already know that Citizenship Amendment Act does not get implemented in the inner line permit areas. So inner line permit is a very simple thing. It's a document, it's a travel document that if you have to travel in several states such as Arunachal Pradesh, such as Nagaland, Mizoram, Manipur, you need that travel document, that inner line permit. Now, why this inner line permit implemented? For the same reason why schedule caste, why 6th schedule and 5th schedules were made. To preserve the autonomy, to preserve the culture. Okay. Preserve culture and integrity and demographic composition. It restricts land and job access to the outsiders. It operates as a tool for internal border control. And in these areas, the Citizenship Amendment Act of 2019 is not implemented. Along with this, in the 6th scheduled areas. You must keep this information in mind. So it derives its legal backing from Bengal Eastern Frontier Regulation Act of 1873. So these are laws which are implemented in several areas in particular states where it is of paramount nature to preserve their local culture, to preserve their uniqueness, to preserve their land, to preserve their jobs. And for that, the inner line permit is implemented. Enemy property. Government plans control for public purposes. Now, what is this enemy property? Those countries which were at war with India and their nationals who holded some property in India and now they are gone. Now, their property is called as the enemy property. So, there are two countries which were at war with India, Pakistan and China. So the nationals of these two countries who holded some property here, for example, a person who was living in, let's say, Delhi or Lucknow or anywhere and has moved to Pakistan and became the citizen of Pakistan and is now living in Pakistan, what happens to the property he has left back? Now that becomes the enemy property. Who takes the control of that property? It is the government who takes the control, total control. And there was an amendment made to the already existing act. This was the Enemy Property Act of 1968. So all these properties were taken up by the government under this act. There was a change, an amendment was made to this particular act. Now there will be total control of the government. The heir of the person on whose name the property is registered, if the heir comes here and asks the inheritance will not be given because it's an enemy property. So no inheritance will be given. And if that property is taken up by the government can use it for monetization also. So these were the changes made in 2017 through an amendment in the 1968 Act of Enemy Property, that no inheritance right to the legal heirs, wastes entire control with the government, and enables monetization. So government is planning and is also planning, not only planning, it's also selling these properties in the open market on the market rate. Those are, too much of land are there. Acres and acres of land of enemy property are there, which can be used and monetized for public good in India. And government is doing it. Now, this is one of the important aspect on which question can be asked. You must pay attention to all the articles. High Court in India reaffirms the need for an individual's right to be forgotten. What is this right to be forgotten? Is it written anywhere in India? In the Indian Constitution. Right to be forgotten forms the part of right to life and personal liberty under Article 21 of the Constitution of India. Think about a situation when a person who was wrongly taken up by the police authorities on several charges and the person did not do anything, and later on it was revealed that the person is not guilty and he has been acquitted. But if you go and search his name on the search engine, you will find his name. And what if the same person goes to a company and asks for a job? The company will be prejudiced, thinking that the person has some criminal record. And there is a possibility that the company may not employ that person. Another situation is when a person went to jail, it was proved that the offense was done by the person and the person has served his term. And then he comes out of the jail. What about then? Will he be given any job? Will he be given a house on rent? Will he be given loan by the bank or not? Now that is the problem with the justice system. If we want the reformative justice system, then after the person has completed his punishment, he should be forgotten. And he should be forgotten from the internet also. That when you go and search the name of the person, you are not going to get any criminal record of that person, because the person was either acquitted by the judiciary or the person has already served his terms. So he should be treated as a normal person. He should not be treated as a criminal for all his life, even after he has completed his term, even after he has completed his punishment. So this issue of right to be forgotten comes up. That when on search engines, the name of the person is searched, all the negative news which are not relevant today, which are of no use today, comes up. And that forms a perception about that person, which hurts his right to life and personal liberty, which hurts his dignified life or his self-respect, which is against Article 21 of the Constitution of India. So it's the right to remove or unlink personal data from online platforms. Though not explicitly codified in Indian law, the courts have read it into Article number 21. And also there is one law, Data Protection Principles, which are given in Data Protection Act of 2023. So what are the challenges? Balancing privacy with the freedom of speech and no unified mechanism for redressal. These are the challenges which are there in the right to be forgotten thing. But you must remember that it is the right of the person under Article 21, and if a question is asked, which of the following forms the part of Article number 21? For example, if they give right to privacy, bodily integrity, and right to be forgotten, and they ask which of them forms the part of right to life and personal liberty under Article 21 of the Constitution of India, you must mark all of them. Okay? This is why we are reading this current affairs, because these current affairs are linked with the articles. The current affairs are linked with the static part of the Indian polity. Moving on. Anti-defection law. We all know this is included in 10th schedule of the Constitution of India. Let's see what has happened. Anti-defection law and article number 191. So, defection during the general election, it reignited that the debate over the effectiveness of anti-defection law. Anti-defection law was implemented because of the simple reason that in the lure of posts and other benefits, the member of parliament or the member of legislative assembly must not leave their parties and jump onto the other parties. So there were several provisions which were made in the anti-defection law, but there are also some criticism. After the implementation of the 10th schedule, after the implementation of the anti-defection law, it was seen that the party leaders have become too powerful. If let's say you are the member of parliament and you want to dissent from whatever your party stance is, you're not allowed. So what is the meaning here? Okay, you should have the basic freedom to dissent from the view. Maybe you do not hold that the same truth which they are holding, or maybe you do not like the point of view of the party, or you dissent from the point of view of the party, and you just vote in the other direction, or you speak in the parliament in some other direction which is not aligned with the viewpoint of your party. What happens? Anti-defection kicks in and you can be removed from your post. You can be removed as a member of parliament. That has made the party leader very strong. That has made the whip very strong. So these are several criticism of 10th schedule or anti-defection law, that it does not allow the individual member of parliament and the member of legislative assembly to hold his own point of view, which can be against the point of view of the party he is representing. And also there are several provisions, such as the one that voluntary giving up the party membership or voting against the party direction, you can be removed from your post. There is also an exception that if a merger is done by the 2/3 of the party member have merged with the other party, then anti-defection law will not be implemented. Okay. And who is the decision-making authority while taking the decision on defection or any case of anti-defection or removal because of anti-defection? It is the Speaker in the Lok Sabha and the Chairman in the Rajya Sabha. But you must remember, all these anti-defection cases can be judicially reviewed by the court. The person can approach the court and the person can represent himself in the court, keep his own particular opinion, why he did what he did and because of what he has been removed, and the decision can be taken by the court. So judicial review is allowed here. How the Supreme Court clamped down on bulldozer demolition. So this bulldozer demolition is taking place. We are talking about Article 142. Now Article 142 gives the power to Supreme Court to do complete justice. Recently also in one of the case, Article 142 has been invoked by the Supreme Court. Recently, if you have seen the case on Article 200, the power of the governor which was curtailed, that the governor should not hold the bills for too long, and several timelines were made that if within 1 month the governor has to give the assent to the bill, and if the bill comes back in the same way or with several changes, then within 3 months the assent has to be given by the governor. Even if the governor is sending that particular bill for the consideration of the president, the whole exercise has to be done within 3 months. This judgment came, you must read about that judgment. Several changes were made in Article 200, but coming back to Article 142, what happened through Article 142? There were 10 legislation on which the governor was sitting, and we are talking about the Tamil Nadu state. The governor of Tamil Nadu was sitting on 10 laws which needs to be assented by him, and he did not assent him and sent it to for the consideration of the president. So all these 10 laws were made acts by the Supreme Court using complete justice under Article 142. So this was in news. This has been in news so many times. Court have used it also in the Babri Masjid case. Court have used it in Bhopal gas tragedy case. Then in recent demolition cases also. Okay. Environmental protection cases also in relation to Article 200 also we have already seen here. So it exemplifies judicial creativity, but it also raises separation of power concerns. What is the role of executive? It was the duty of the governor, or if the bill is sent to the consideration of the president, then it was the duty of the president to sign those 10 bills. But they were made act by Article 142 by the Supreme Court. So there were concerns over the breach of separation of power principle. Okay, moving on to the next one. Collegium. Now collegium has been in news so many times. So what is there on collegium? Vacancies in the high courts and delay in appointment revived scrutiny of the collegium system. So what is the basic idea of this collegium system, and why are collegium system implemented? I mean, what does the collegium system do? Collegium system became powerful after the 3 judges cases. Before the 3 judges cases, what used to happen, if you have to transfer a judge or if you have to appoint a judge to the Supreme Court or to the High Court, it was the president who used to appoint it, and the consultation was made by the president from the Chief Justice of India. So the president used to consult the Chief Justice of India before appointing a judge. So it was wholesale the power of the government to appoint a judge into the High Court or to the Supreme Court. But after the 3 judges cases, this word consultation got changed to concurrence. That whatever consultation or whatever recommendation which is provided by the Chief Justice of India for the appointment and transfer of a particular judge has to be followed necessarily and shall be followed by the President of. So all the appointments which were done by the President of India has to be approved by the Chief Justice of India, or in a way the Chief Justice of India through its collegium system was the one who was the most powerful body to make the judges, to appoint the judges. And the government now has no say in it. It is the president who appoints it, but only after the consultation from Chief Justice of India, and that consultation is concurrence. That the consultation has to be followed. The president is bound to follow those consultations. I hope you are getting it. And this collegium system has been criticized widely because of its opaqueness, opaque function, for the lack of representation and diversity, and for delay in clearing recommendation. So National Judicial Appointment Commission bill came in 2015. In one or the other way, it gave wide representation in the appointment and the transfer of judges. If you see, it was a 6-member body which consists of the Chief Justice of India and 2 more judges, two eminent persons, one law minister. So 3 people and 3 people. These 3 came directly from judiciary. Law minister was the part of the executive. And these 2 eminent members, they were appointed by a committee which consists of the Chief Justice of India, the Prime Minister, and the leader of opposition. So in a way, if you see, the National Judicial Appointment Commission gave a very, very wide representation. Judiciary was the part of it, executive was the part of it, and the legislature was also the part of it. But it was declared null and void, it was struck down because in one or the other way it was infringing upon the separation power. It was infringing the basic structure of the Constitution of India, separation of power principle, and for that reason it was struck down by the Supreme Court. And now there are also debates going on around the country after the cash has been found, burnt cash has been found from the house of a High Court judge about the collegium system and the opaqueness of the collegium system. There is no transparency, there is no accountability, and this is one way where judges appoint judges. It does not happen anywhere. If you see the practice in some Western countries, in America or in Britain, they do have a more representative way of electing or nominating or appointing the judges. So some change is required, but in the word of the Chief Justice, the ex-Chief Justice of India, that it is not the perfect system, but it is better than many of the systems which were already existing. So let's see what happens in future. Moving on to the last topic, this is the Chief Justice of India, not the present Chief Justice of India, pitches for All India Judicial Services. Now, if you want All India Judicial Services now, Indian Administrative Services there, Police Services there, and if the government wants to add one more judicial service, what needs to be done? Simply the role of Rajya Sabha, the Council of State, comes here. Because in some or the other way it is going to infringe on the federal structure of the country, because this service will be there representing the union and the states both, and it is a matter which relates to the federalism. That is the reason why prominence is given to the Rajya Sabha. Rajya Sabha passes a resolution by 2/3 majority, by special majority, to empower the parliament to establish a all India service. Now this is the procedure which has to be followed. It is the Rajya Sabha which empowers the parliament to make all India services, to establish all India service. And if all India judicial service has to be established, it has to be established in this way, where under Article 312, Rajya Sabha passes a resolution. Hello students, welcome to Sriram's IAS, welcome to this live class 50 most important topic. Although we have completed our 50 topics for Indian polity, but there are few topics which are left. So we will be covering those few topics, and it will be very handy for you for your upcoming examination, prelims examination on 25th of May 2025. So let's begin our class. The first topic is about the National Commission of Backward Classes. Now why was it in news? Because of the inclusion and exclusion of OBC from the central list. This was in news, along with the issues of subcategorization, along with the issues of creamy layer. All these things, because of all these things, National Commission of Backward Classes was in news. So it recommends inclusion of 7 communities in the central OBC list for Maharashtra. Moving on, all these news which comes, why they become important? Because they are linked with some or the other static topic. Now this is directly linked with Article 338B of the Constitution. That simply means National Commission of Backward Class is a constitutional body. Although originally it was not a constitutional body, it became a constitutional body by 102nd Amendment Act, Constitutional Amendment Act. Okay, 102nd Constitutional Amendment Act. Similarly, National Commission for Scheduled Tribe, National Commission for Scheduled Tribe was also not there in the original constitution, but was added later on by the 89th Constitutional Amendment Act. This was in 2003. Okay, so National Commission of Scheduled Caste was there in the original constitution. So it is important for us to understand the articles which are allotted to it. Article 338B for National Commission for Backward Classes, Article 338A, this was also inserted later on for the National Commission of Scheduled Tribes, and National Commission of Scheduled Caste is there in the original constitution under Article 338. So 330, you must remember these three are constitutional bodies. Earlier, National Commission of Backward Classes and National Commission of Scheduled Tribes were not a constitutional body, but it became the constitutional body after the 89th Constitutional Amendment Act and 102 Constitutional Amendment Act. You must remember this. So the constitutional status was granted by 102 Amendment Act in 18. What is the function of National Commission for Backward Classes? It safeguards OBC, okay, the other backward classes. It does everything related with OBC. The inclusion of any backward classes into the central list is done by the President after the advice made by the National Commission of Backward Classes. It also looks for the welfare of the backward classes. Grievance redressal and policy advice it gives. And the composition, there is a chairman, there is a vice chairman, and there are 3 members. Similarly, the same composition is there for National Commission of Scheduled Caste and National Commission of Scheduled Tribes. Power, it has the power of civil court and it reports to the President directly. Okay. In the Maratha reservation case also, its role was huge, that it was about to advise the President on inclusion or exclusion of a community in the central list. Moving on to the next topic. 47,000 complaints are filed with National Commission of Scheduled Caste. As we have seen, this was present in the original constitution under Article 338, National Commission for Scheduled Castes. And the complaint relates to land disputes. So this is also a body which looks after the welfare of the scheduled castes, which look after the grievances redressal of the scheduled castes. It is a very, very important body, and it's a constitutional body and comes under Article 338. So Prevention of Atrocities Act also, it looks after this act. Now this act have been passed in 1989. It provides for the punishment if some crime is committed against the members of this scheduled caste community. It also provides for compensation by the state for the harm caused, physical harm or intellectual or mental harm caused. Recently there was a case where the years of research of 2 Dalit scholars who belong to the scheduled caste category was burned down in a home dispute. They approached the Supreme Court for compensation. So a great question came in front of Supreme Court, whether the intellectual property, means the research paper and everything was the intellectual property, whether the intellectual property of 2 Dalit scholar can be considered as a physical damage or not. And Supreme Court said that it should be considered as a physical damage, that the physical damage done to the property, to the bodily integrity of a scheduled caste community member, then the central government pays the compensation. The government also has to pay the compensation if there is any loss of intellectual property of a member of scheduled caste community. So it's an important thing you must remember. It also looks under the reservation and welfare provisions, redresses the grievances related to caste discrimination. These are very important body. In one or the other way, it tries to uphold Article 14 and Article 21 of the Constitution of India, right to equality and right to life and personal liberty. Because if these are not there, these bodies which looks after the welfare of the communities is not there, then the marginalization of these communities will start again. or else we can look it in a very different angle, that whatever marginalized has been done, to undo that, these bodies are of great use. Okay, moving on to the next thing. Amid NEET row, UPSC to revamp its exam system with new technology. So now UPSC is also one of the current affair here. So this Pooja Khedkar row which took place and the NEET scandal which took place, cheating can be done in the UPSC examination, not in the examination but while filing the papers, the caste papers or the papers related to the age of a person, physical handicapped, all the certificates which are there, and certificates can be made, this what we call it as fake certificates can be obtained from authorities and can be submitted to UPSC. Certificates related to caste, related to the income category, related to the physical handicapped. Now to streamline all this, and this Pooja Khedkar row which has happened should not happen the next time, the use of artificial intelligence and technology has been done by Union Public Service Commission. So now let us understand about Union Public Service Commission. It's a body which conducts exams in India, or all the top level exam. The exam for which you are preparing is conducted by UPSC for the All India services, for central services. If in future the All India Judicial Services comes in, the exams will be conducted by UPSC. It is a constitutional body under Article 315 of the Constitution. You must remember this. It's a very powerful body and it's a constitutional body under Article 315 of the Constitution. Recruitment is through open competitive exam, the exam for which you are preparing, advising the government on service matters, and it ensures meritocratic appointment. So the independence of UPSC is of paramount nature. If the chairman and the members of UPSC are not independent in taking their decisions, they can be manipulated by the political class. They can be manipulated by the economically well-placed people. And for that reason, some kind of independence has to be given, and Constitution ensures their independence through several things like fixed tenure. They can be removed before their tenure. They also have prohibition of removal except as per the Article 317. Article 317 provides several grounds and the manner in which they can be removed. They cannot be removed in any way on the whims and fancies of the political class. But there shall be a procedure which should be followed. There is a mechanism. Only if they did something wrong, if they are shows incapacity or are going against the Constitution, things like that. Budget charged on the consolidated fund of India. So it symbolizes integrity and efficiency in public administration. It's a current affair topic. It's a very important topic. Can be asked in your upcoming examination. You must study it well. Constitutionality of the electoral bond scheme. So electoral bonds, it was struck down by the Supreme Court recently in one of its judgment. So what is this electoral bond? Simply put, electoral bonds relates to the donation made to the political parties. There are many political parties in India. India is a multi-party democracy. Political parties form a very important part of the democratic system in India. The parliamentary form of government depends on the multi-party system in India, isn't it? And to run a political party, you also needs funding. Cannot be done without funding. And for funding, donations are needed. So there wasn't any transparent way for donations in the political parties in the past. So in 2017, a law was brought, a Finance Act was brought, although it was considered as a money bill and was passed by the Lok Sabha without a proper scrutiny of the Rajya Sabha. It was criticized because of that, but anyway, electoral bond scheme was implemented. Now all the political parties which have got at least 1% of votes, means there must be some standing of the political party, some ground. Why should Or else, any political party, any person can make and register a political party with the Election Commission of India according to the Representation of the People Act, and then can route black money through shell companies to a political party. So for that reason, to be eligible to get the electoral bond and donation through electoral bonds, it was necessary that the political party in India should at least get 1% of the votes. Now, if a political party is getting 1% of the vote, that is eligible for this scheme of electoral bonds. Now, what is electoral bonds? Again, so we are going to understand this with an example. If a person, let's say this is a person who wants to donate to a political party, and this is a political party here. So earlier what used to happen, this person used to go directly and donate to the political party, put the money inside the bank account of this political party. To avoid this direct thing, a scheme was brought. A scheme was very simple, that this person will not directly donate to the political party, but rather this person will go to the bank, preferably SBI, and will purchase a bond. That bond will be called as electoral bond. SBI is not going to distribute these bonds or sell these bonds throughout the year, but only 4 times in a year. That too 10 days, for 10 days each time. Okay, so in total SBI will be selling these electoral bonds for about 40 days in a year. Now in those 40 days, a person has to go and purchase that bond from SBI. They will be in the denomination of 1,000, 10,000, 1 lakh, 10 lakh, like this. And a person can purchase a bond of any denomination. Whatever amount of money the person wants to donate, the person can buy an electoral bond of that value. Now this person, once he buys the electoral bond, and now he has the electoral bond and he had submitted the money with the SBI. Let's say this person wanted to donate 10 lakh rupees to a particular political party. He has deposited 10 lakh rupees in SBI and got that bond of 10 lakh rupee. Now this person will go and give this bond to the political party. Okay, this person will directly go and give this bond to the political party. The political party has to redeem this bond within 15 days. Okay, the bond does not, in one or the other way, we can say, had the information of who is buying the bonds. So this became the very basis of why Supreme Court struck it down. Supreme Court struck it down because of the simple reason that it was infringing the Right to Information Act of the people. That the information which is required, that who is donating to the political party, was not available in the public domain. Okay, so this bond scheme which was there, which in a way it is just, bonds are like promissory bonds, but promissory bonds have the information of who is buying the bond and to whom the bond is paid. But in electoral bonds, the information of who is buying the bond and to whom it is paid was not available. It was only available to SBI. Now the Supreme Court have directed the SBI in the case, when this matter went in front of the Supreme Court, it has directed the SBI to disclose the name of all the people who have donated to the political parties to the Election Commission of India. And then Supreme Court further directed the Election Commission of India to make the names public. Okay, so that was the story of electoral bond. As of now, the electoral bond are not there in the market. They have been struck down, and the donation to the political parties are going on as per the previous rules. So the electoral bond, they were introduced in 17 via amendments through a Finance Act. So some key legal changes were made. Exemption from disclosure under Companies Act and Representation of People Act. So this became the point of contention. The exemption of disclosure, which is against the right to information which is provided to the citizen of India under Article 21 of the Constitution. Because of this, the electoral bond was struck down. Unlimited corporate donations were allowed. Foreign funding restriction diluted via FCRA amendment, Foreign Contribution Regulation Act amendment. So foreign funding restrictions were diluted. Huge amount of foreign funding was also allowed. Any citizen of India can donate, and also the non-citizens can also donate through this electoral bond. So critics argued that it violated Article 19 of the Constitution. Right to information also comes under Article 19 of the Constitution and promotes opacity. Article 21 also, right to life and dignity also, this article also gets covered by the right to information, you must understand. So the issues and the concerns: anonymity. Donor identities were hidden from public. It was violating right to know. Only the bank knew who was the one who purchased the bond, and then it was given. So the name of the person who is donating was not there in the public domain. And that was the reason why Supreme Court has struck this scheme down. Corporate dominance, removed the corporate donation cap. That means a corporate house or a person, a businessman can donate any amount to the political party, risking undue corporate political nexus. This was one of the bone of contention. Crony capitalism is already there. Then this corporate political nexus was going to be a huge setback for the democratic system in India. Lack of transparency, it contradicts the RTI norms and electoral integrity. And then money laundering risks were also there, that it also allowed the shell companies to donate without scrutiny. Shell companies can be foreign also. The contribution limits were diluted through FCRA Act. Now ethics, parliamentary conduct and the Indian MPs. So the ethics committee of the parliament, this is a very important committee of the parliament. It became a permanent committee of the parliament in 2015. Initially it was a standing committee, an ad hoc sort of a committee. It looks into the matters related with the ethical conduct of the members of the parliament, not only inside the parliament but also outside the parliament. If anything is done or said by the member of parliament which is considered unethical, an inquiry is done or inquiry is conducted by the ethics committee. Now while conducting the inquiry, it can also summon the member of parliament to its meeting. And the report of this inquiry has to be submitted to the speaker, has to be submitted to the chairman, either in the Lok Sabha or the Raj Sabha. So that is the power of the ethics committee, and it is very much needed. That was not a very ancient phenomena. I mean, that ethics committee did not start at the commencement of the constitution, but started to come in the practice later on, and especially became a permanent committee in 2015. So they operate in aid of Article 101 and 102. 101 talks about the vacation of seats and 102 about the disqualification. So it aids Article 101 and 102 in one or the other way, we can say that. So that is what is ethics committee. It examines the complaints against the member of parliament, it formulates code of conduct, and it recommends disciplinary actions. So these are important aspect of ethics committee. Okay, moving on to the next topic. Stormy winter session ends with dismal output. So it is all about the parliament and the working of parliament, declining efficiency of parliament, declining productivity of parliament. And why this is happening? Because of frequent adjournments. Why frequent adjournments? Because of frequent protests. Instead of debating and deliberating on a subject, the member of parliament have found out a new way to either come into the well with postcards or start disrupting the sessions of the parliament or stage a walkout. So all these things does not help in deliberation or debate in the parliament. The parliamentary process is very pure and sacred and has to be followed in the right manner. Okay, and this public money is spent. Each minute, thousands and lakhs of rupees are spent for running the parliament in security, and so many other expenses are there. So, the expenditure of the public money, that is one concern. But parliament is there for a larger purpose, and it is unable to show its productivity in the recent time because of frequent disruptions, frequent protests, and frequent adjournments, which was not there in the past. I don't know why it feels as if the member of parliament does not enjoy debating in the house. Anyway, if a bill has to be passed because of the brute majority of the ruling party, it will be passed. Just shouting, protesting is not going to change the ground reality or the numbers in the house. But anyway, opposition plays its own role. Opposition plays a very important role in a democratic system, but opposition should not protest or disrupt the sessions of the parliament. Rather, they should be focusing upon deliberation and debate within the parliament. That is how people are going to respect them more. That is how people are going to value them more. They know more than us. Shortened sessions are there. Then, lack of debate on bills. Some of the bills are passed without discussion. Also, this Rajya Sabha, this money bill route. If you declare, and who has the power to declare a bill as a money bill? The Speaker of the Lok Sabha. If the Speaker of the Lok Sabha declares a bill as a money bill, it doesn't have to go through the scrutiny of the Rajya Sabha, because the majority power when it comes to a money bill is held by the Lok Sabha. And in Lok Sabha, generally, not in this session, but the previous two governments, the majority in Lok Sabha was very brute. Okay, so that was another thing which was trying to surpass the the democratic value and the democratic procedures in the house, in the parliament. So dedicated time for opposition, these are some suggestions which can be implemented, that there should be some dedicated time for opposition. For your prelims exam, it is very important if you read article 107 to 122, which governs the legislative functions of the parliament. If you give dedicated time for opposition business, it will be, there is a question hour. Dedicatedly, the first hour of the start of the parliamentary session of the day, the opposition can ask questions. Okay, so there are mechanisms, but still a dedicated time for opposition business will help. Automatic expunction of the disorderly interruptions. Now the chairman or the speaker have the power to expunge the disrupted speeches and speeches which are made, which are beyond the time limit which is allotted or are not according to the democratic value or the ethical value of the country. Revival of pre-legislative consultations. So pre-legislative consultations are very, very important. If you bring a law in the parliament, disruption is bound to happen. But if that particular law which has been introduced in the parliament, if there is a deliberation in the pre-legislative stage, then it will be better. Then the disruptions are going to be far more less. So these are few advices which can be implemented. Strengthening deliberative democracy is essential for upholding constitutional governance. All these lines are very important for your mains examination. You can use it in introductions or in conclusions. Those are very important. So zero FIR, online police complaints. If you see section 154, that is very important. Section 154 of Criminal Procedure Code. In a way, it is police's obligation to file a FIR if you approach them. Now, sometimes police do not file the FIR. Many times the police try to ignore you, or many times the police just does not listen to the people who have reached to the police stations. So it is the obligation, and for better efficiency and the productivity of the criminal justice system, these two initiatives are of great use, zero FIR and e-FIR. Now everybody knows about e-FIR. E-FIR is simply an online FIR. Anything happens with you, you can file a FIR using your mobile phone and internet, and it reaches to the police station of the jurisdiction. Similarly, there is another thing which is called as zero FIR. Now, zero FIR is a mechanism where you can make a complaint or file an FIR in any police station throughout the country, irrespective of the jurisdiction. If, let's say, some crime has been committed in Delhi, but when you know about it, you are somewhere in Calcutta. So you can lodge an FIR in Calcutta in some police station. Later on, it will be sent to the police station of the jurisdiction where the crime was committed. So these FIRs, these zero FIRs and online FIRs are of great use for the efficient working of the criminal justice system in India. EFIRs enable online filing of cases, typically non-cognizable offences. They enhance access to public justice, of course it does. Promote victim-centric policing. So now to report a case and force the police personnel to work on that case is in the hand of the people. They can do it anytime through online FIR or zero FIR. Even when the police personnel is not listening to you, and if you file the FIR online, he has to listen to you. So the power is in the hand of the people now to promote the victim-centric policing, and it reduces procedural delays. Okay. So both stem from police's obligation under section 154 and reinforces constitutional protection under Article 21 of the Constitution. Linking APAR ID with Aadhaar, a case of government circumventing a judicial ruling through administrative means. What is this APAR ID? We must have heard about the DigiLocker, but what is this APAR ID? Now the DigiLocker system is the online mechanism where you can you can keep your driving license or your Aadhaar card or your PAN card or your certificates, the educational certificates and everything. But this APAR ID is related to the academic certificates which you have, academic credentials which you have. So it's a part of the National Digital Education Architecture under the National Education Policy of 2020. So this is the digitization drive of the government, that you can have all your academic credential in your hand, in your mobile phone, everywhere. Similarly, there was this DigiLocker also, that you don't have to carry the physical copy of your driving license or the physical copy of your PAN card. You can have that installed, issued by that particular institute. For example, PAN card, the issuing authority issues the PAN card, the digital PAN card, and you can show the digital PAN card or the digital driving license anywhere, and nobody can deny that under the DigiLocker thing. Similarly, there is this APAR ID. You don't have to carry your certificates everywhere. You can upload it in your mobile phone, in your APAR ID. If let's say you have to show your certificate to some authority, you can show it on your mobile phone also. If you click the photograph and then show it, it may not be admissible. But once through the APAR ID, the certificates, the educational certificates, 10th certificate, 12th certificate, degree certificate, mark sheets, they have been issued by the issuing authority, by the university, by the Central Board of Secondary Education or ICSE, or by the State Education Board. Now that is acceptable by the authorities. So that is what is APAR ID. It aimed at universal student registries from preschool to higher education. It ensures streamlined governance and educational mobility, supporting Article 21A and digital inclusion. So all these are the drives of the government. The digital drive of the government may be of some use to you for your upcoming prelims examination. So study, just know about this automated system. Now, power of pardon. India keeps it rare, the US does it more. So the power of pardon, some time back, the former President of the United States, Joe Biden, have given pardon in one of the cases to his son. And this issue of pardoning power of the president has came up. So in India also, president and the governor, who are the sovereign powers, have the pardoning power. But there is a bit of a difference between the pardoning power which is used in India by the president and the governor and the pardoning power of the president of the United States. Under Article 72, the president enjoys the pardoning power, also the powers to remit, respite, reprieve, commute a sentence. Similarly, under Article 161, the governor enjoys the same power. But there is a bit of a difference. Governor cannot pardon somebody for death sentence or for court martials. But the President of India can pardon anybody for offences under union law, for court martial sentences and for death sentences. This is usually done to correct the judicial wrong, to correct the judicial mistakes, and also to show compassion. Now when you say pardon, it simply means to acquit the person. The person just walks out, walks away from the punishment, and that is the power which is given to the President of India by the Constitution. Now comparing it with the power which the President of the United States have, Article number 2 of section number 2 of the Constitution of the United States wastes this power in the hand of the President of the United States. And this power is a near absolute power. Okay, this is a near absolute power. He can use it whenever he wants upon anybody he wants, the US President. Whereas the President in India and the governors in India act on the aid and advice of the Council of Ministers. They cannot do anything on their own. It's not the absolute power of the governor or the president to show pardon or to issue pardon orders. So that is the difference which you must understand. The Indian President acts on the advice of the Council of Ministers during the pardoning thing. This was a Maru Ram case, which was a very important case. And the US President exercises personal discretion. This is the difference. It's a very basic difference which you should understand between the pardoning power of the US President and the Indian President. Important environmental law. Now, Article 21 of the Constitution has become a mammoth, has taken a mammoth, composition. It has become very huge. Many of the laws, many of the rights, such as right to bodily integrity, right to privacy, right to marry anybody of your choice, right to information, all these things, although not explicitly written under Article 21 of the Constitution, has been included in Article 21 of the Constitution by the interpretation of the Supreme Court, the interpretation of article number 21, because Supreme Court says that right to life and personal liberty simply means having a life which the person lives with dignity. And environment and climate change, they are concerns for human being. So to have a right against climate change is linked with your dignity, and hence it is the right under Article 21 of the Constitution of India. In the recent judgment in 2023, right against climate change was added under the ambit of Article 21 of the Constitution of India. Okay. So right to clean environment, that is also included under Article 21. Intergenerational equity, that is also included under Article 21. Sustainable development, that is also included under Article 21. And right against climate change or right to climate protection is also added under Article 21. These are rights, fundamental rights given to the citizens. Now, courts increasingly treat climate stability as an extension of human dignity and public trust doctrine, blending directive principles of state policy such as 48A and the duties under 51G with enforceable right. What is these enforceable right? Which are justiciable. It simply means fundamental rights. So the issue of environment is not only present in the fundamental rights under Article 21, but also under the directive principle of state policy under Article 48A and the duties under Article 51AG, where the citizens have the duty to protect the environment, flora, fauna and wildlife. Important environmental law orders judgment passed, we have already done this, I think. So now, this is another thing, inheritance tax. So, you know what is inheritance? Inheritance is simply when the father transfers or the grandfather transfers their property, the family property, to the heir, to the son, or also to the daughter now. We are not living in an era where daughters are not given the equal rights. They are given the equal rights also in inheritance, in different personal laws of different religions also. So, this inheritance which is done, for example, there was a property or a land or some, you know, there are huge properties belong to people and they want to give it to their son, they want to transfer it to their sons and daughters. Now that is what is inheritance. The property which was holded by your, it's also called as the parental property, which is holded by your forefathers, is coming down and is handed over to you, and you are expected not to sell it but to hand over to your next generation. You also have the right to sell it if you want, but usually in India, people are emotionally linked with their inherited properties. People are linked with their parental properties and usually they do not sell it. So if it is a parental property and has been transferred in your name, that is what is inherited property. Now, this inherited property, no tax is imposed on this. On the contrary, if you buy something, if you buy a piece of land and then you sell that piece of land after 10 years or after 5 years, the amount of money which you have gained, capital tax is imposed on that money. Whatever you may have earned, capital tax is imposed on that money. But inheritance tax is not there in India. But there have been debates and deliberations to impose the inheritance tax also. India repealed estate duty in 1985. Currently, inheritance is tax free, though capital gain tax apply to asset transfer. So we have already seen the difference between capital gains and inheritance. Capital gain can happen anywhere. See, the transfer can happen anywhere. You can buy from an unknown person, but the inheritance only happens in family. Your father transfers the land or the property in your name. That is the parental property. That's called inheritance. You are the heir to that property. So argument in favor are that it reduces inequality. That simply means if you impose the inheritance tax, it will reduce inequality in the society. And there will be funding for social scheme, because the amount of money which will be earned by the government through inheritance tax is going to be huge, and it can be used in the social service or welfare schemes in the country. Argument against is it is administrative burden. Through the robustness of this inheritance tax, because everywhere this happens, so administratively speaking it will become a burden, although it will not be that a big burden, because other kind of things also happen where the government collect taxes, and capital flights and tax evasions will be there. So if your property which your father wants to transfer, this is the parental property, and the father wants to transfer this to an heir, then let's say if this property costs 1.5 crore, the father is only going to tell that this property is around 80 lakh, so that the person has to pay less tax. So all these things, tax evasion and capital flights, that will be the other problem if the inheritance tax is implemented. Any reintroduction would require a comprehensive legal framework under Article 265, which is the tax power of the government. India restores diplomatic immunity to Canadian province trade representative. So diplomacy and the diplomatic immunity is of great use. Reciprocity is one of the principle which is applied and which is practiced. That simply means that you give immunity to our diplomats in your country, we will give protection and immunity to your diplomats in our country. That is the basic principle on which the diplomatic immunity works. Diplomats, the American or the British diplomat or the Bangladeshi diplomat or other diplomats from different countries who are living in India, they have some kind of immunity. They have immunity from civil cases and criminal cases. The host state for all the diplomats who are living in India, so India becomes the host state. Host state must ensure protection of diplomatic premises and personals. So whoever living in the high commissions or whoever the staff of that particular country which are living in the embassies of that country, the protection of the premises and the protection of the personals living inside that is the duty of the host country. If you go to Chanakpuri area in Delhi, you will see so many embassies and high commission. The protection of that area, the protection of embassies and the people living inside that is upon the India state. Similarly, our diplomats which are living in different countries, their security is in the hand of that country. And of course, immunity is given. Civil immunity and criminal immunity is given. So if, let's say, the United States of America provides immunity to our diplomats, we are going to provide immunity to their diplomats also. And it will be reciprocal. Let's say they decreases the immunity or the standards of immunity, then we are not liable. We are also going to decrease the standards of immunity. But there is also a law through which all these things works. There is a convention, Vienna Convention on Diplomatic Relations 1961. India has ratified it. And through this convention, the diplomatic immunity is given to all the countries, all the diplomats living in different countries. Now there is this violation of personality right. This is another category of rights which are in news nowadays, included in Article 21 also. What is this personality right? Having control over your name, having control over your voice, having control over the way you walk and talk and everything, so that your personality and the traits of your personality cannot be used without your consent, without your permission in any ad or any film. That is what is called personality rights. So personality rights refer to the right to control commercial use of one's identity, such as name, image, voice, likeness. In India, it is protected as an extension of Article number 21, right to privacy, Article number 19, right of expression, and a tort law where your identity can be misrepresented. So this misrepresentation should not happen, and the Indian law protects the personality of a person. The traits of the personality of a person cannot be used against their consent. So this is one new category of fundamental rights which is emerging, and although courts have not said anything, but there is also a landmark judgment such as ICC Development versus RV Enterprises, and the recent celebrity cases have clarified the contours of these rights. Court often balance them with journalistic freedom and public interest. If a journalist, let's say, goes and takes a photo or does something which catches the trait of a particular personality, now that will be allowed. Or else what is the use of a journalist? Why are you becoming a celebrity if you don't want to come into the limelight? So these things have to be balanced. Similarly, just because you are a celebrity, everybody can use your personal trait. Now that is also not good. Several, these ads, the fake ads are run, or even the good advertising companies use the name and the voice of several celebrities without their consent in the ads. That is also not acceptable and also not permissible. Don't forward cases of those covered under CAA. Now we are going to read about the Foreigners Tribunal. This is a very important thing, Foreigners Tribunal, and this is working in Assam, although it has to be implemented throughout the country, but as of now this is working in Assam. It's a quasi-judicial body constituted under the Foreigners Act of 1946. It has some key functions. What are the key functions? It determines whether the person is a foreign national or not. It sees through all the ways and the means and the procedure whether the person is the Indian citizen or not, and if he is not the Indian citizen, then the foreign tribunals report this to the police in order to deport that person to the country from which he has originated. Review cases referred by border police or NRC authorities. Now this is another key function of the Foreigners Tribunal. It provides the individuals the right to representation and appeal. So this has came into news because of the CAA, the Citizenship Amendment Act of 2019, and the recent rules which were made in 2024. Now CAA, you must be knowing, it gives the Indian citizenship, a fast track Indian citizenship to all the persecuted minorities from 3 different countries which are the neighbors of India. The 3 different countries are Pakistan, Afghanistan and Bangladesh, and the persecuted minorities are Hindus, Sikh, Christians, Parsis, Buddhists and Jainism. So all these 6 communities from 3 different countries, if they are persecuted minority and they can show some proof of persecution in these 3 countries, they can come to India and become the citizen of India within very less time. All the people who have entered India belonging to the persecuted minorities and belonging from these 3 countries who have entered India before 2014 were already given the citizenship of the country. So the amount of time required for naturalization to become the citizen of India was reduced to 5 years. So foreigner tribunals, now these are implemented specially in Assam. Why? Because Assam is dealing with the problem of illegal migration from Bangladesh. So it becomes paramount to pinpoint who are the citizens of India and who are the outsider, and that work is done by the Foreigners Tribunal. Press freedom of India rapidly declining. So there are data which is showing that the press freedom of India is declining rapidly. The data or the report is given by the Reporters Without Borders. There are also Doctors Without Borders. Similarly, there are Reporters Without Borders, which measure the media freedom based on pluralism, transparency and safety. So what are the challenges to press in India? Arbitrary arrest of journalists, we have seen. Journalists are sometimes arbitrarily arrested without a proper ground. Then they are kept in jail for a long period of time, and after the intervention of the court, they are acquitted. Now these kind of things, in one or the other way infringes upon the freedom of press. Okay. Also, the open-minded journalists were shot dead in the recent past. There were so many instances. Internet shutdown. That is another thing, because the media is not only limited to the mainstream media or the news channels. Today, Twitter or X, Facebook, all these online media, the social media platforms forms a very important part of media. So internet shutdowns directly impact this social media, where the people are journalists, where the people are reporting from the ground. Threats to press independence. So Article 19 guarantees freedom of speech, but it is subjected to reasonable restrictions. Sovereignty, security, public order. These are the reasonable restrictions. Upholding media freedom is essential for democratic disclosure. We all know this. The only problem is that we have to implement it. Okay. Now, this is going to be the last topic, Central Consumer Protection Authority. Now, Central Consumer Protection Authority have came up with new things, new advertising guidelines for consumer awareness. So, many things have been sold to you, sold to everybody, and advertisements have been done. Sometimes the advertisement does not tell the real nature of the product which they are selling. For example, some advertises show the junk food as a very nutritious food. So that is not a good thing. It's a sort of fake information which is being circulated through advertisement. And against these kind of information, new advertising guidelines and consumer awareness, consumer awareness, to improve the consumer awareness, new advertising guidelines have been issued by the Central Consumer Protection Authority. Now this authority is a very important authority which works for the welfare of the consumers in India. So these rules seek to regulate misleading and surrogate advertisement. One of the example which I gave you just now, where the fast food is shown as a very nutritious food, and also sometimes when cartoons are coming on television, usually children are watching them. Different kind of advertisement come which can impact the mind of the young people, which can impact the mind of the children. That is also not allowed under the guidelines. Mandatory disclosures and paid promotion for social media influencers. So what kind of disclosure is done? That if they are making advertise for some product, the nutritional value of that product has to be disclosed. Along with it, if a social media influencer have taken money or have been paid to make an ad, for the circulation of this particular product, whatever product it may be, then the influencer has to tell that I have been paid for the promotion of this particular product. That is what his disclosure means there. Penalties under the Consumer Protection Act of 2019. So what does this new advertisement guidelines do? It enhances the informed consumer choices and transparency. So in one way, Article 38 of the Constitution, which is the directive principle of state policy, relates to the social welfare, is directly linked with this new advertising guidelines, which protect the people from bad choices they can make through the fake advertisement. and also article number 19. So this was it. Thank you very much for joining me in this class, and the topics of Indian polity are completed now. We have done many topics of Indian polity which will be of use for your upcoming examination. We have also linked it with these static topics which will be of great use to you. Thank you very much for joining me. Keep watching this video, keep watching our other videos for your welfare, for your